Good morning. All right, welcome to the U.S. Patent and Trademark Office and the National Patent Application Drafting Competition Finals. I'd like to say the energy and anticipation in this room is palpable, although I think I'm sensing some tension and anxiety right now. Hopefully, as we roll into the start of our day and the start of the competition, those nerves are going to break free and you all are going to be the fierce competitors that I know you can be. My name is Elizabeth Doherty, and as the Northeast Regional Outreach Office, I want to welcome you to our house, a house built on and for American invention, innovation, and entrepreneurship. The USPTO, as America's innovation agency, protects and serves those who decide to accept one of our nation's greatest bargains. In fact, what we call the grand bargain. Disclose your invention to the world such that others can make or use it, and we, the federal government, will allow you to exclude others from making, using, selling, or importing your claimed invention for a limited period of time. The exercise that you have undertaken today is to represent one of these would-be inventors in bringing forth their life's work, their passion, their attempt to solve a critical challenge or problem facing themselves or another segment of the population. You have taken their idea, their invention, and placed it into our love language, the patent application. Through your drawings, claim drafting, and arguments, you are striving to achieve the dream of your inventor, to grab the brass ring and to walk away with a U.S. patent that can leap their ingenuity and ultimately company into a strong startup stance and perhaps one day a spot in the chairman's circle, a company which is an industry leader in their field. Today's competition brings together the top 5 regional NPADC competition winners who have risen from a sea of 44 teams competing from 38 nationally recognized law schools. Now, in case you're doing the math, that's right. 6 law schools fielded more than one team. One of those schools is here today in our finals. We're pulling for all of you here today and want to congratulate all of the teams who have participated in this year's competition. Today's competition will be fierce yet professional, demanding yet rewarding, and bottom line, fun. So first, before introducing our esteemed judges to you, I would like to thank all of the USPTO staff who has been involved from the very start of this program, those that are located at our regional offices, those that are located here at our headquarters. For those of you who are with the USPTO who are present physically in the room today, please wave a hand so that everyone here in the audience and who are watching us virtually can see and recognize you. Thank you. Thank you for your support, hard work, and efforts that have made today's program a possibility. So at this time, it is my pleasure to introduce to you today's esteemed judges. These 3 individuals represent the best of the IP profession. Going in alphabetical order, we have Brad Chin. Brad is a registered patent attorney who counsels and represents clients concentrated in the energy and high-tech industries. Brad's deep technical experience, industry and market knowledge, and background as a chemical engineer equip him to counsel clients in managing IP portfolios and strategic business relationships. His practice focuses on assisting clients with patent and trademark procurement and enforcement, licensing and technology transfer, invalidity, non-infringement, and freedom to operate opinions. Also post-grant review proceedings, government contract compliance, and corporate due diligence. He also represents clients in intellectual property litigation matters before state and federal courts. Prior to entering private practice, Brad served as a U.S. patent examiner for the United States Patent and Trademark Office and as an intellectual property manager and counsel at Raytheon Company. Prior to entering the legal profession, he served in the role of technology licensing manager for the Technology Licensing Office at Texas A&M, Go Aggies, and a multidiscipline process engineer at Raytheon Corporation, where he designed and manufactured missile systems. Thank you and welcome, Brad. Next in our lineup is Linda Horner. Administrative Patent Judge Linda Horner currently serves as the acting senior lead judge of the Patent Trial and Appeal Board, or PTAB. She is leading a team at the USPTO to advance all things involving the PTAB and oversees collaborative initiatives between the USPTO and the U.S. Food and Drug Administration. She joined the USPTO as an administrative patent judge in 2006. And in her career at the agency, she has served as senior legal advisor to the Undersecretary of Commerce for Intellectual Property and director of the USPTO. In that role, she counseled the USPTO director on a wide range of patent-related legal and policy issues. She has also served as an acting vice chief judge of the board, and prior to joining the USPTO, she was a partner at a law firm in Washington, D.C., where she represented clients in patent matters before the USPTO and federal courts. She received her law degree from Boston University School of Law and her bachelor's degree in mechanical engineering from Cornell University. And last but certainly not least, Nick Matich. Prior to returning to the agency, and welcome back, Nick, Nicholas Matich was a principal in McCool Smith's intellectual property practice, representing a broad array of clients in IP disputes, both as plaintiffs and defendants, advising clients on IP strategy. Prior to joining McCool Smith, Nick served as the acting general counsel of the USPTO, where he represented the agency before the Federal Circuit and U.S. Supreme Court. Prior to assuming the role of acting general counsel, Nick served as senior legal advisor in the office of the director. In that capacity, he personally briefed and argued a number of high-profile appeals on behalf of the USPTO. Nick has also served previously as the Deputy General Counsel at the Office of Management and Budget, as a presidential appointee on the governing body of the Administrative Conference of the United States, ACUS, and in the White House as a special assistant to the President and Associate Staff Attorney. Prior to his service in the government, Nick practiced at several prominent law firms and worked as a law clerk for the Honorable Richard Wellesley of the United States Court of Appeals for the Second Circuit. He earned his bachelor's degree at the University of Notre Dame and his law degree from the University of Virginia School of Law. Competitors, I can't tell you whether it's going to be a hot bench or a cool one today, but I can assure you, you are in great hands with today's judges. So welcome again to the USPTO. We are here to help ensure that your day and participation goes smoothly. Let's all have fun and enjoy the day. And it's now my pleasure to turn the mic to my colleague, Tamika Obashan, who will share some rules of the road and guidance for today's competition.
Good morning, everyone. Thank you, Elizabeth, and welcome. The rules of the competition follow and will govern the competition. The competition is organized and headed by an organizing committee. The organizing committee may, at its sole discretion, amend or add to the rules of the competition rules at any time. In the event of a rule change, adequate notice shall be given simultaneously to registered teams via email from the competition website. Any questions or interpretation of these rules should be addressed to the organizing committee and submitted via email to npadc@uspto.gov. Decisions of the organizing committee shall be final and are not subject to any form of appeal or review. The organizing committee may, at its sole discretion, disqualify a team if it finds that there has been a serious violation of these rules, or in the event of other behavior that is considered contrary to the spirit of the competition. The panel of judges will base their scores on the team submissions, as well as their team presentation, including the team's ability to answer questions and comments from the judges. During the team presentation, each team will be notified by a timekeeper when they have 2 minutes remaining and when the team's presentation time has expired. Teams must not continue speaking after the expiration of time without first gaining the permission of the panel of judges. During the presentation, team members must not communicate with anyone other than their fellow teammates, the panel of judges, and the timekeeper. Coaches are prohibited from communicating with the teams during the presentations. Notes may not be shared other than between teammates. The team with the highest total team score will be the winner of the national finals. Judges' scores are deemed final and not subject to review or appeal. Teams may neither directly nor indirectly observe other teams' presentations unless they have already completed their presentations. By participating in the national finals, individuals are accepting that their written materials, applications, presentations, and appearances may be used, published, video recorded, and/or live streamed, and recordings posted on web pages. And now at this time, I'll ask that the University of Pittsburgh School of Law team remain in the room, and the other teams, please make your way to the adjoining auditorium. Thank you. Hello, everyone. My name is Tamika Obashan, and I'm the official timekeeper for this session. It is now 9:15. Who will be presenting for the team?
Matthew Nealon.
Matthew? Okay, awesome.
Good morning, everyone. Thank you.
One moment.
Oh, sure. Sorry.
No worries. Competitors, you will have 20 minutes to give your presentation to the judges. Judges, you will be able to ask questions during the presentation. The presentation time will not stop to answer questions. Judges will have 10 minutes, or about 10 minutes after the presentation has concluded, to ask additional questions. Your time will be adjusted if there are technical difficulties during the presentation. The official time will be kept by me. I will announce 2-minute warning when there are 2 minutes remaining for your presentation. I will give everyone the same 2-minute warning when there are 2 minutes remaining in the judges' question time as well. You will be allowed to finish your thought when time runs out. When the presentation is complete, you will be asked you can remain in this main room. You may also decide, if you don't want to stay for the next competition, to join the adjoining auditorium room. It is now 9:16. We're about a little bit before time. We'll go ahead and get started.
Thank you. Good morning, and thank you to our judges for being here, USPTO staff, Elizabeth and Tamika, for setting this up, and everyone else working behind the scenes to make this a great competition. I'm Matthew Nealon, joined by my co-presenter, Ryan Estatico, from the University of Pittsburgh, and today we will be presenting on our strategic patent protection strategy for maximizing the scope and the value for the extrauterine system, the invention. An overview of our presentation will include our initial claim drafting strategy. We will move on to our comprehensive search strategy as well for navigating the prior art documents that were identified. We will include some of these search results and the relevance of these documents in informing and refining our claim strategy. We will also include discussion of some of the representative prior art documents that were provided to us and our associated amendments in light of them. And we'll finish up with some of our strategic reasoning and value maximization for the inventor in this case.
And a quick overview of our claim drafting strategy. We chose to do 3 independent claims to capture an inflation chamber, the precision sealing mechanism, and the adjusting the size of the environment as our core functional aspects. And this included a system claim, an apparatus claim, and a method claim. And we used dependent claims to add granular protection for key commercial embodiments and to also provide fallback positions during prosecution.
So we chose 3 independent claims to ensure that our inventor got the best return on their investment. With the non-provisional filing, you get 3 independent claims, and so we made sure to use all of these. So choosing the specific claim types that we did, the system, the apparatus, and the method, each informed each other. And so our system claim was designed so that competitors could not slightly alter system architecture and elements to avoid infringement. Similarly, we have an apparatus claim in there to protect the commercial embodiments of the invention that could potentially be circumvented from a system claim alone. We also included a method claim to potentially cover use of the device and apparatus during physiologically supporting a fetus. And all 3 claims were drafted with the idea that they would work together in synchrony, potentially forming the backbone of a patent portfolio for our inventors in this case. And you'll see our figure 7 describing one of the high-level overviews of the system. So we didn't choose a computer-readable medium claim for this competition. These are valuable primarily for software-based inventions, and arguably here, the core innovation did not necessarily lie in the software. It is possible that in the future, a CRM claim could be pursued in a continuation to broaden the scope of the invention and provide our client with additional value that could protect their invention from infringers. This is why we chose the system, the apparatus, and the method claim as a more direct and comprehensive approach to claiming the inventive concept. So our system claim is claim 1 in dependents 2 through 4. We believe that this provides the broadest functional protection for the invention. The system claim is designed to encompass the integrated uterine system as a functional device. It focuses on what the system does, namely physiologically supporting a fetus, and it does this in a responsive and dynamic manner. And we did this rather than just reciting specific components because we believe that this could provide greater protection for the inventor against infringers. This would also allow our inventor to catch direct infringers who in the future may potentially manufacture or sell the extrauterine system. We believe that while the claim, due to its breadth, may not necessarily be the broadest in a general sense, but we believe it encompasses the entire inventive concept and would be the most valuable to the inventor in this case. And similarly, this system claim could potentially form the cornerstone of a patent portfolio, providing a broad initial layer of protection for future iterations and innovations to occur off of.
And next, we wanted to look how we could complement our inventor's entire invention to provide component-level protection by adding the apparatus claim of Claim 5. And these claims target the specific apparatus and components of the system. In this case, it's the elastic chamber and its sealing mechanism. And this provides a strategic advantage to our client as it targets component manufacturers of just the apparatus, which who may not make the entire system, but they specialize in manufacturing and selling the key component or the sealing mechanism. And it's also a design around deterrent for our client and their competitors, as it makes it harder to design around the system patent by also protecting the key components individually. And they would need to infringe both, to avoid needing to infringe both the system and its parts. And it also provides them with licensing opportunities in the future. Component-level patents can create licensing opportunities with companies who might want to incorporate the patent components in their own systems.
And lastly, we have our method claim, Claim 7, and associated dependents 8 through 10. So these are designed to protect the use and process of the invention. So this is the method of actually using the system, which focuses primarily on the dynamic and responsive nature. So this provides the advantage of potentially targeting end users or service providers. It may encompass those who use the system in an infringing manner, whether that's hospitals, neonatal care facilities, or medical facilities, with limits that we'll discuss. And this provides us with enforcement flexibility as well by not simply relying on system claims or apparatus claims alone. So this could potentially cover the actions of the infringer rather than just the physical product. And so, like I said, this expands our reach to cover more than just manufacturers or sellers of the system to potentially end users of the device, giving our inventor greater value for this initial application.
In this invention,
Counsel, I had a question. So I noticed that in Claim 5, you do not have the inflation chambers as part of the invention, but in the other independent claims you do. And I wanted to understand what your thinking was with respect to that.
we believe that the apparatus claim provides protection of the sealing mechanism and of it includes the flexible chamber to host the fetus within the claim. So it was that component level protection of that pod that we wanted to encompass within our claim.
Thank you.
You're welcome. And moving on, this competition tested our understanding of this 35 USC, specifically Section 287C, which provides medical practitioner immunity, where medical practitioners are immune from patent infringement liability under specific conditions. So what this meant for our patent drafting strategy is we wanted to target the manufacturers of the product and the testers of the product, and not just the end user, which would likely be the medical practitioner. And how we did that within our claims is we focused the claims on targeting those that make or sell the extrauterine system itself or the combination of the components, such as the biocompatible membrane, the inflation chambers, and the control system. Some examples of this within our claims is Claim 5, the apparatus claim, targets the apparatus for physiologically supporting the fetus, and it's crafted to be infringed by a manufacturer making or selling the apparatus, not when it's in use. And another example of this is the method claim to target the steps performed during system use, such as testing the equipment or going through approval through its various avenues. And these claims target the steps involved using the system to support a fetus, such as modifying a life-sustaining fluid or adjusting at least one condition within the closed sterile fluid environment, providing a holistic approach in light of the immunity clause. And another place where the method claim is important is through the FDA approval process, such as device testing. For FDA safety, the approval may infringe the method claims. So in summary, how we use the medical practitioner immunity clause within our claim drafting strategy was to pursue the manufacturers for infringement through making and selling device, and pursue the end user of infringement in system usage where applicable, but not as the main focus of our claims. And next, we had a multi-level, we're going to talk about our search strategy. We used a multi-level attack plan when dealing with this. So first, we brainstormed what is our core concept of the invention, what are our key features, what problems we're trying to solve, and we generated keywords based on these ideas to help start and kick off our search. And we also used CPC codes for classification-based searching within the field of invention. And we used multiple databases within our search to have a holistic approach to the market. And as well as the ones shown on the screen, we also used non-patent literature, such as PubMed and to try to find clinical studies in Google Scholar to try to find research around this invention. And with the Asia-focused and Europe-focused ones, we did that where applicable and used translation to the best of our abilities. Oh, yeah. And so here we have examples of our keywords that we used within our search. So we have the overall idea, the extra-uterine system, and then words that surround the art within the market. And as you see, we narrowed the subject matter down to the fetus, and then we broadened it to encompass other inventions that would be within the art. And then we had the components and the functionality as well. And we combined these search terms with Boolean operators to provide the best results, to have a full understanding of the prior art.
So due to the nature of our search, we reviewed.
Counselor,
Yes.
sorry, a quick question going back to the search results
Absolutely.
or search strategy. Did you identify any other owners of similar technology and consider their patent portfolios in kind of a comparison analysis?
We tried to. Many of the references that came to our attention were linked to entities that were more so like solo inventors, it appeared. And so there weren't necessarily portfolios attached on Google Patents specifically. This gave us the functionality where we could click on the inventor and see what similar inventions they had, similar with the entity. And we were not able to find anything more than an additional 2 or 3 patents that were particularly relevant, at least from our search.
Okay, great, thank you.
So due to the nature of our search, it did reveal a number of references that were potentially relevant. And so going through each of these and determining which were the most relevant and which might be material to patentability and were worth inclusion in our information disclosure statement, we note that we found the Chirikov and the, I believe, Finch reference, or Fuchs reference, that were also provided in the representative prior art that was given. The other prior art documents, such as Krishnan, Langer, and De La Porte, were generally directed to the material selection, which we initially thought might be a unique element of the invention. Similarly, the biocompatible membrane and the system as a whole. And so going through each of these references, we had to determine whether specific components were present in both our invention disclosure and also in the prior art, and then whether a combination of references might be potentially obvious just based on the nature of the invention and the level of ordinary skill in the art.
Did you find any references that disclosed an artificial womb system that would change size with the size of the fetus and or strain gauges that would measure any changes in the size of the membrane?
I don't recall anything with changing size. I do remember with strain gauges specifically, there was not any references I recall that used the phrase strain. I think there might have been some references that, generally discussed like tension and other related physical aspects of the system, but nothing that demonstrated strain in the way that it was described by our inventors regarding, changing the size and shape of the flexible chamber. So moving on to the representative prior art documents that we were given and reviewed. Like I said, 2 of them we already had and considered in our initial claim drafting. And so that gave us a validation of our strategy and also allowed us to have a strong basis going into this portion of the competition regarding whether we would need to amend the claims or not. And after reviewing the documents, their various teaching, considering the various components that were disclosed in isolation in each document, and then also in combination between the documents, and what sort of obviousness type rejections may be possibly formulated by an examiner, we determined that our initial claims were potentially drafted too narrowly for the representative prior art that we were given. And so we decided to slightly broaden our claims and provide greater claim scope for the inventors. So, namely, this involved amending out certain limitations of the claims that were not disclosed in the prior art. There were key limitations that we believed were potentially going to be novel and be the focus that did not end up being the focus. And so we were able to remove some of these limitations to provide greater scope for our inventor. So specifically, our claim 1 was amended to remove a recitation of what the flexible chamber does, namely mimicking a mammalian uterus. And similarly, we were able to amend out the life-sustaining fluid insertion step because of potential divided infringement concerns with the initial claim. And claim 2, we removed one of the location descriptions of the flexible chamber. We initially recited on an outer periphery, and we determined that the location of the chamber was not necessarily core to the novelty based on the representative prior art that we were given, and we were able to amend that limitation out. Similarly, claim 3 regarding a temperature altering sensor, we believe the inclusion of this might be potentially relevant during prosecution, depending on what was found in the representative prior art. It was determined that this feature was not necessarily going to be a point of novelty, and so we removed it. Moving down into our apparatus claim.
2 minutes.
Thank you. We were able to highlight the useful nature of the hinge and also the the precision sealing mechanism. So we clarified some language there that we thought might be potentially helpful for an examiner in reviewing the application. And then the other claims also include similar removal of limitations such as on an outer periphery, and in claim 10, the limitation that the machine learning happen based over time.
And here to conclude our strategic reasoning and how we decided to maximize the value to our clients, we did 3 things. First, we wanted to balance the scope while still keeping it valid under the prosecution rules. So we wanted the claim structure to achieve broad protection for the core innovation while ensuring validity through the specific embodiments. And we did this by relying on our dependent claims to further describe the invention and provide fallback positions during our prosecution when this would happen. And we wanted to keep compliance with Section 112 to ensure the specification supported and enabled our invention, and also to provide the additional fallback positions during prosecution if needed. And this was a tough balance because it's the page limitation of the specification, but it was a good exercise for us during the prosecution. And next, we wanted to focus on the infringement and enforcement concerns of our clients. And so we wanted to give them broad independent claims to provide the strong basis for injunctions against competitors. And we wanted the claims to capture economic value and enable substantial damages if they were to be infringed upon. And we wanted the method claims to further strengthen the enforcement of protecting the novel process. And third, we wanted to maximize the commercial value by adding granular protection to make design rounds difficult for our competitors. And we wanted to provide a set of claims that we could build a portfolio upon in the future by not overly limiting them and focusing on the core innovation. And third, we wanted to provide the strong market position and raising capital and maximizing return on investment for our inventors by capturing what the core invention was during our process. Thank you.
Thank you. Judges?
So you talked about, if you could go back to that last slide. You talked about the maximizing the commercial value, and you've talked a few times about building out a portfolio. How would you advise the inventor or your client based on kind of the breadth, and you've obviously analyzed the prior art and thinking about your claim scope, how would you advise the client on building out the portfolio?
Red zone?
There we
Okay,
go.
sorry. So in this case, because we were limited to 10 claims total, it's certainly limited based on, wanting to do 3 independent claims, maximizing that. It limited our dependent options. And so from a portfolio first approach, I think filing continuations with greater dependent numbers for the system claim, the apparatus, and the method would be advisable. I think there were aspects that we ended up pulling out from our amended claims that could be potentially relevant in a continuation, depending on where the field goes, where potential competitors appear to be going. And so if our client wants to get ahead of the competition, potentially block competitors from entering certain spaces or researching aspects that might be potentially useful, we would recommend that, at least initially from a portfolio building standpoint.
And just to add, I believe our claims focus on like the physical structure mostly of this invention. So there can always be additions of like monitoring, machine learning in the future when that becomes applicable.
Thank you.
Counsel, I want to ask you a question. Let's focus on claim 1 for a moment. So the second half of the claim, you have the one or more sensors that are configured, and they're configured to monitor fluid and membrane data and then adjust parameters. Suppose you got a rejection that those are not supported in the spec because you don't specify in the claim what kind of sensors, what data you're monitoring, or what the adjustments are going to be. How would you respond to that rejection?
Yeah, that's certainly some that we would take back to our client and see. We believe the specification does have support, certainly for the sensor types, but then also for potentially the types of data that is being used. We would take that back to our client and see if there are specific aspects of the invention that they believe would be most likely present in a commercial embodiment. So for example, they could come back and say, temperature is very important. Temperature seems to be the most important thing for us. And that would potentially inform an amendment strategy, whether to include a temperature sensor specifically, and then also the temperature data as well. In light of the prior art, whether temperature itself would get over the art is maybe questionable, but we would definitely advise our client that inclusion of potentially more structural detail could be favorable and would not necessarily cede much claim scope.
And suppose you got roughly the same objection, but under 101, would your response change?
101 would certainly make things a little difficult. I think in this case, our system claim shouldn't face 101 issues. I believe, even, that it's the core invention would be eligible and would not recite a judicial exception. However, we think that there's support in the specification to potentially argue, even if there is an alleged abstract idea, integration at step 2B, or even under a streamlined analysis, we think that this would be potentially, clear to one of ordinary skill in the art, the benefits that it provides and the advancement over the art.
And I believe also under 101, our sensor within the system is providing data for it's like a real component providing data for our system to use, and it's making adaptations based on that. So I think under 101, we'd have a strong argument.
Your claim 1 requires the one or more sensors to be configured to measure real-time membrane and fluid data. Could you broaden the claim to just have one or the other and not both?
So we considered this, and certainly in our initial claim drafting, we wanted to include both of these because we weren't sure what sort of art was out there. In our sort of broad understanding of the nature of this, simply reciting one of them we did not believe was going to be potentially novel. And so by reciting both of them initially, and then getting the representative prior art, that sort of confirmed to us that, had we just recited temperature, temperature is known in the art. And so including temperature with the other aspect was potentially a novel step and could provide a pathway to a patent.
Following my fellow judge's question on a rejection by an examiner, and you said you would respond, or kind of talking about the temperature or many different types of sensors. If the examiner were to come back and present another piece of prior art, right, generally describing sensors, it would make the rejection of sensors of common knowledge in the art in many industries. It would be obvious to include any type of sensor. You mentioned maybe defining more specifically what temperature range. Maybe I didn't see that in the specification, but what if they came back with that rejection? I often get those rejections where they're adding in a kind of related prior art, but obviously citing to a reference that has an element that is fairly general in the industry. What would be some different options you would have in responding to that, if you've thought about that?
Yeah, absolutely. So in our understanding of Claim 1, we were trying to find aspects that were potentially novel. Sensors, generally known in the art, but whether the specific use of the sensors in combination with the other elements, most importantly, the inflation chambers, we believed was something that could provide novelty and would overcome any sort of obviousness rejection. We were not able to identify prior art that combined these elements or art that potentially had suggestions that this could be possible, and we would potentially argue against any sort of obviousness combination of a generic sensor and potentially an abstract inflation chamber found in some reference.
Additionally, our Claim 3 talks about how the membrane and fluid data includes one or more temperature measured in real time by one or more of the sensors. So we could also fall back on Claim 3 if we were to get that rejection.
Great, thank you.
Turning to Claim 5, your apparatus claim, can you talk a little bit about what you found in the prior art and why this was a focus? Like, did you find other systems or apparatus that had some sort of opening, but they were different in some way and how they were sealed or hinged? Or can you talk a little bit about the art?
Yeah, so some of the prior art documents, namely the ones that broadly described a system of supporting a fetus, did describe a chamber of some kind. This would be fairly obvious, whether you have a uterus doing it or whether it's an extrauterine system doing it. So we wanted to make sure that whatever we highlighted in this claim would be potentially novel. The precision sealing mechanism itself, discussing the ways in which the pressure is applied from both sides, we were not able to identify in any of the prior art documents, and so that informed us in saying, okay, this appears to be the most novel aspect of what we want to claim with this apparatus. Let's include that in our independent claim, and then from the dependents we can get a little bit more narrow and see what sort of art is out there.
Suppose you got a rejection on Claim 5 for precision sealing, and the examiner said, I think that's indefinite. I don't know what you mean by precision. How would you respond to that?
Yeah, I know our figure, I believe it's 3, shows the precision sealing mechanism, might be 2, but we would certainly point out to the examiner the figure. We would point to the description in the specification. If that was unpersuasive and did not provide what they thought was, the level of detail necessary, we would consider adding additional limitations, more specifically describing what the precision sealing mechanism actually means, the temperatures needed, which I believe we discussed in the specification, or excuse me, the ways in which the precision sealing mechanism is done with the pressure from both sides. We would go back to our inventors and obviously offer that as a potential pathway for the apparatus claim.
Would you consider defining precision, and if so, how would you define it?
I think the specification provides a little bit more description of what a precision means. We could include a wherein clause saying wherein precision includes an application of pressure from both sides in a sterile. May I finish your question?
Yes.
Thank you.
Yes, please.
Where the application of pressure provides this sterile environment, and so we may define it in that way. We're saying the precision is regarding this, sterile nature of the apparatus specifically.
Thank you.
Thanks, everyone. This concludes Team 1's presentation, University of Pittsburgh School of Law. Gentlemen, you can remain in the room or you can go to the auditorium if you'd like. Hi, good afternoon. My name is Tamika Obashan, and I'm your official timekeeper for the session. Just a reminder, we have a robust virtual audience in attendance as well, and thanks for joining us today. Who will be presenting for the team? Wonderful. All right. Now, competitors, you'll have 20 minutes to give your presentation to the judges. Judges, again, you will be able to ask questions during the presentation. The presentation time will not stop to answer questions. Judges will have about 10 minutes after the presentation has concluded to ask additional questions. Your time will be adjusted if there are any technical difficulties during the presentation. The official time will be kept by me. I will announce a 2-minute warning when there are 2 minutes remaining for your presentation. I will also give everyone the same 2-minute warning, including the judges. You will be allowed to finish your thought when time runs out. When the presentation is complete, you will be asked to either remain here or go to the adjoining auditorium room. Okay, are there any questions? No? Okay, then you may begin.
Morning, everybody. We were hoping to get a cool walk-up song like Elizabeth got, but maybe notes for next year for the competition. Well, thank you for joining us and taking time out of your day to hear our presentation. We're at the University of Wisconsin Law School. So today, a brief overview of what we'll be discussing. We'll talk about our patent application summary, the different considerations that we made along the way for trends in patent law, and to make sure that our claims are strong and enforceable. Next, we'll talk about the prior art that we found, the prior art that was given to us between the regional and the final competition. And then we'll discuss how that prior art shaped our claim strategy into what it is now after the regional rounds with our amendments. Then we'll talk about how those claims are enforced and different market considerations. So a brief introduction of myself. My name is Brent Brunner. I am a 1L at Wisconsin with a background in mechanical engineering.
Hello, my name is Wang Kyo-jung. I'm also a 1L at Wisconsin Law, and I studied bioconvergence and economics for undergrad. It's an honor to present here today. Thank you so much. We focused on patentability and enforceability for our application strategy. On the patentability side, we emphasized novelty and non-obviousness for our claims. For enforceability, we thoroughly researched potential infringement, which we will go into detail after presenting our claims. We also addressed recent trends in patent law, referring to cases like Alice, which heightened scrutiny under 35 U.S.C. Section 112. We avoided overly broad or vague language, and we ensured subject matter eligibility by supporting our functional claiming with concrete structures that detail the function. Our cohesive extrauterine support system is designed to sustain a premature fetus and support its healthy development by replicating integrated functions of the womb in a controlled artificial environment. We supplemented the figures provided in the invention disclosure to fully enable our claimed invention. Figure 1 shows the overall system view, followed by Figure 2's umbilical cord to catheter port system. Figures 3A and 3B illustrate the heat-sealed door mechanism, open and closed. We drafted our independent claim 8 on this feature. Figure 5 showcases the plurality of inflation devices surrounding the chamber, strain gauges shown as dots, and various sensors. These elements support our independent claim 1 on the disclosed fetal positioning mechanism, which serves as an umbrella for many of our dependent claims explained in detail soon. Additionally, we added on to Figure 1 elements such as the power source and waste removal system to fully illustrate our system's holistic functionality.
So now we'll turn to the prior art. So after sifting through all the prior art that we found, and again was given to us between the regional and the final round, we focused on 3 main publications that were relevant to our claims. The first 2 are the 350 publication and the 197 publication by a common inventor. We noticed that we knew we were on the right track when we found these because of how similar they were to the figure 1 that was given to us in the invention disclosure. The 197 publication is particularly relevant because of the introduction of carbogen. We note that this has distinct differences from perfluorocarbon, a PFC, that we end up using as one of the cornerstones of our independent claim 10. The 096 publication is particularly important for 2 reasons. The first being its mechanical lid. We claim in our independent claim 8 a heat-sealed door. However, this lid is more of a mechanical latch that's attached to the top, and so we think that is distinct from our claims. Further, you know, on the bottom of that figure, lead line 3 going in and figure 1B has that disc at the bottom, and that's used to introduce oxygen bubbles to the system, which is relevant to our independent claim 10.
We identified the 4 key innovations in our disclosure and systematically applied them in our prior art analysis. For all 3 prior art references we examined, the 350 pub, the 197, and the 096, we acknowledge that they each disclose a closed sterile fluid environment. However, the remaining elements, specifically the life-sustaining fluid, the optimal fetal positioning, and the elastic membrane that stretches, expands, and returns to its original shape, we found that each reference lacks or teaches away from at least one of these features. These gaps form the basis for our novelty arguments. This is shown through the 350 pub, the 197 with the caveat of carbogen 7, and the 096 pub.
Okay, so let's talk about our claims. How did that prior art shape our claim strategy? So first, we'll talk about the claim amendments we made between the regional and the final rounds. We took a lot of advice from the judges of the regional round on how to improve our claims. And the main thing that we changed was we wanted to target deep pocket infringers. Our first round of claims we thought read too much as that the medical physician was the infringer, as the judges advised us to go after more of the manufacturer. So we changed method claims to system claims and other small amendments to make sure that it was the manufacturer was the infringer. Second, we wanted to avoid unnecessary claim limitations. This is shown in our independent claim 10, which we initially claimed 2 inlets, and the judges proposed the easy design around it. What if we had 1 inlet instead? Would that be infringing? So we decided to change it to a fluid supply rather than an inlet to not have to worry about the possible design arounds. So here are our independent claims in summary. We have 3 independent claims and 7 dependent claims. Independent claim 1 is a system claim for a microprocessor controlled fetal positioning. Independent claim 8 is for a heat seal chamber door, and independent claim 10 is to that PFC amniotic fluid mixture. So here's our independent claim 1. This is an extrauterine system for supporting a premature fetus. It has a chamber, a fetal position sensor, an actuation device, and a microprocessor. So how does that all work and compare to each other? So the fetal position sensor will sense the position of the fetus within the chamber. It will then generate a signal and send it to the microprocessor, which determines whether it's within a desired range. If the microprocessor determines it's outside of that range, it will control an actuation device to readjust the position of the fetus until it is within that desired range. We underlined those 2 terms in the previous slide because we want to note what they're referred to in our specification. The fetal position sensor is broad enough to cover 2 embodiments in our specification. It can be the plurality of strain gauges, 142, which are positioned around the chamber to measure deformation of the chamber to see growth of the fetus or position of the fetus within the chamber. Further, it can be a motion detection sensor, 158, some kind of optical device. And this can also see how the fetus is growing or where it is positioned within the chamber. The actuation device can be inflation devices 166, where are inflatable balloons, where fluid can be brought in, such as air, via a pump, 174, and relief by relief valve, 178. Here's a claim tree for our independent claim 1 with dependent claims showing the relationship to the independent claim. Dependent claim 2 is to that strain gauge idea, saying that the fetal position sensor can be a strain gauge. Dependent claim 3 is to an optical device, which broadly will cover a motion detection sensor. Dependent claim 4 says that the actuation device is an inflation device. And dependent claim 5 says how that fluid or air is brought into those inflation devices by a pump and or a relief valve to adjust the pressure. Dependent claim 6 we think is a strong fallback, potential fallback position. This claim talks about the temperature control of the fluid within the inflation devices. So there's a temperature regulator within each inflation device. It can actually control the overall system's temperature by those temperature sensors within the device, and overall by conduction, the fluid within those inflation balloons can actually heat or cool the environment that the fetus resides in. Dependent claim 7 is to acidity control, which is a similar sensor to microprocessor relationship.
Counsel, could you go back to the last slide?
Yes.
How would you respond to a rejection from the office that claim 1 is unpatentable under 101 or 112 because it lacks the structure that's provided in the other claims, something along the lines of you say you got a sensor, but you don't say what kind of sensor. You say you're monitoring position, but you don't give any specificity in the claim language about what position you're going for or how you achieve the position adjustment.
Sure, yeah, we would argue that we think it is fully shown and that there's enough structure there. If an examiner would continue to disagree with us, we would implement some of the dependent claims to further specify what actual that structure is. Independent claim 8 is again to that broad idea of the heat-sealed chamber door. So we have a chamber, a door rotatably coupled to the chamber between an open and a closed position, and a heat-treated sealant position at the outer periphery of the opening. So in practice, a fetus will be placed in the chamber with, again, the door in the open position. The door would be rotated, closed, and then a heat-treated sealant would be applied. There would be a very sterile seal, and that sealant could be silicone or polyurethane, as said in dependent claim 9. And we note that this is distinguished from the prior art. So the 197 publication has an oval opening 10, but it doesn't contemplate how that oval opening is sealed. Rather, it says the oval opening is there. And so we think that is distinguishable. Similarly, the 096 publication, again, remember, has that mechanical lid with those latches. And we think that is uniquely distinct and wouldn't have the same benefits as a sterile seal for a heat-treated sealant.
If an examiner were, to present a rejection, present a new piece of prior art to a heat-treated sealed door, right? Maybe related art, maybe not related art. How would you respond to that office action that would have that rejection?
So are you saying it would not be within like an extrauterine system, some kind of other?
Correct. Let's say it's not within a uterine system. The examiner is saying it would be obvious to choose another type of sealed door into the system. What would your argument be?
No, I think there's maybe two types of arguments here. We could say that the unique benefit here is that kind of sterile environment that the heat sealed would produce. We think that with the 096 publication, maybe a mechanical seal is not as strong, maybe like that you could still have contaminants get in. We think the actual heat sealants, may be the best option, and that would not be like an obvious distinguish from that. We might also do a hindsight bias argument and say, well, you're only saying that once you saw our application and you're going, and now you're finding exactly what you want because you saw what we did. In our independent claim 10, we note that we can see that this is our most aggressive claim. We had 3 independent claims for this exercise, and so we wanted to be aggressive with our last claim. And so for this claim, it goes after the broad idea of an amniotic and a PFC mixture within the chamber. So we have a chamber, an amniotic fluid supply, a PFC fluid supply. They mix within the chamber, and the fetus is at least partially submerged within that mixture. And we note that this is close, but it is uniquely different from the 197 publication's Carbogen. So PFC is different from Carbogen in several ways. PFC does not break down as much as Carbogen would and would not fluctuate the carbon dioxide of the system, therefore causing possible injuries to the fetus while it is within the system. And so we think that if we met with some kind of obviousness type rejection, we would argue that the PFC is not obvious distinction, rather it's a beneficial one that the inventor came to. Further, the prior art is distinguished from the 096 publication, which teaches fluorocarbon. However, we note that the 096, remember, it has that disk, that bubbling oxygen that comes into the system. It does explicitly state that because you have this oxygen-rich gas or these air bubbles, the system eliminates the need for any kind of oxygen-carrying vehicle, some kind of liquid. So it would be a frustrated purpose to, if there was some kind of obviousness type rejection with this art, because it explicitly says that we don't need an oxygen-carrying liquid or kind of vehicle because we have these air bubbles to provide the oxygen to the fetus.
When you were drafting Claim 10, did you think about the infringement in terms of who would be providing these components? For example, the manufacturer of the chamber, maybe not the same supplier that supplies the fluids, and how would you get it, infringement?
Yeah, we did consider that, and what we came to was the idea of kind of like an owner's manual, like infringement idea. So if someone supplies this chamber and says you need to include these two kinds of fluids with it, we think they would still be the infringer, because you have to apply that exact fluid to the system, even though they aren't supplying that exact fluid, rather just the chamber system.
Now we'll discuss our patent's enforceability, crucial for managing infringement and protecting patent value. The artificial womb market targets critical societal needs, reducing fetal mortality, preventing complications from prematurity, and offering a safer alternative to traditional fetal care. The market is projected to double by 2030, and neonatal care is identified as the fastest growing segment, highlighting future opportunities for expanding our fetal support system into adjacent neonatal care technologies. We recommend filing in strategically selected jurisdictions. In North America, the United States and Canada offer a strong market demand and established healthcare infrastructure and well-defined regulatory frameworks. Mexico, while less predictable in terms of regulation, remains strategically important due to its emerging market potential and proximity within the North American trade zone. In Europe, countries like Germany and the Netherlands are ideal targets given their leadership in medical innovation and their sophisticated regulatory environments. Finally, China and other Asia-Pacific nations present substantial market opportunities as well, given the size and incentives to promote birth rates in some countries. Furthermore, Claim 10, which protects the PFC amniotic fluid mixture, presents a key licensing opportunity, as this component is both novel and critical for fetal viability. Likewise, Claim 1, which covers microprocessor-controlled fetal positioning, represents a valuable asset for medical device companies seeking to incorporate real-time monitoring and dynamic fetal regulation into their prenatal or neonatal platforms. We identified several organizations across key global markets that might be interested in replicating our key elements and pose potential infringement risks. Vitara Biomedical is developing its Extend system and is in discussion with the FDA following successful animal trials. Their position in the North American market supports our recommendation to file in the US, Canada, and Mexico. Juno Perinatal Healthcare and Eindhoven University of Technology are both based in Europe, with Juno operating from the UK and Eindhoven University in the Netherlands. Together, they are developing a fluid-filled artificial womb system backed by significant EU funding. Their presence in Europe's medical innovation ecosystem, particularly in countries like the Netherlands, Germany, and the UK, make these regions essential for patent protection. We're also observing conceptual efforts like Ectolife on the bottom right, which envisions full-term fetal development in artificial wombs, showing how even conceptual sci-fi-like projects reflect growing market interest and potential intersections with our protected technologies. All considered, our global filing strategy aligns with the geographic locations of key players in the space. This slide highlights how each of our independent claims maps onto existing competitors like landmines across the market landscape. We analyze potential infringement by leading companies in the artificial womb space and assess the strength of our claim coverage against their technologies. Overall, competitors would face significant challenges in replicating a comprehensive fetal support system without triggering infringement across our three independent claims. Together, these claims form an integrated umbrella of protection, covering the system holistically and avoiding the need to file 3 separate patents.
2 minutes.
Did you look for patent holdings from these companies to see what they already had?
Oh, yes, it was very helpful. On their websites, they displayed the particular patents that they filed for their inventions, and we took our time to thoroughly investigate each of them and included them in our prior art analysis. And we have confirmed that there were significant amount of features in these products that we had to design our claim around, so to avoid infringing on them.
Did you look into where each of the companies is doing its manufacturing so that you would have coverage there to be able to cover 100% of their market share?
Yes, we made sure to consider those factors as well. We also made sure that, excuse me. Yes, we also noticed that like these tariff considerations could be factors where for these companies to determine where they manufacture, and like import and export restrictions could be important factors for these decisions as well. So that was something we deeply considered for filing patent strategy in the Asia Pacific region in particular. And yeah, so we did, and yeah. So I believe that we strategized for those factors for IP enforcement.
You've developed quite a robust kind of global patent strategy. If the inventor were to come to you and say, okay, I've been presented with, competitors in the market, drafted claims that potentially don't infringe on any of the existing patents of these other companies, but they come to you and say, I only have X number of dollars, whether it's their own funding or an investor, or they have an investor that might be on the side that might be interested in investing in their company. How would you advise them in terms of maybe what is the priority, whether jurisdictionally, where to file, or based on your patent strategy, which embodiments of the invention based on the claims would you prioritize? How would you prioritize that to the inventor?
Yeah, so I would prioritize, again, we'll start with countries. I think the U.S., Germany, and China, I think would be the best countries to file applications in to start with. If it's limited, I would probably, maybe if I had to pick 2 of those, I'd pick U.S. and probably China, I think would probably be the best 2 options. As for claims, I think our independent claim 1 is the most valuable claim we have. And I think that one has so many potential fallback positions that I think during prosecution, if needed to amend those in, I think those would be really strong claims to bring to those several countries.
Yeah, and particularly for markets in China, it's important to file in China because of the significant amount of competitors in this field of healthcare industry. So in terms of deterring local competitors in the Asia Pacific region, I believe China would be a very important country to consider as well. Thank you.
So I had a question about your amendment. You converted, I believe, all the claims so that there are no more method claims left in the application. And I wanted to, did you give any thought to whether or not you would pursue method claims and how that interacts with patent marking in the event you have to enforce it?
So originally we included the method claims, in the first round, and that was the main thing that the judges highlighted for us as being targeting the doctors or the physicians instead. And so that was the reason for initially getting rid of the method claims. And we kept the figures in there in case at some point, maybe a con down the line we wanted to pursue some kind of method claim in the future. So I think including those, if for some reason we wanted to target the physician or the doctor, we could. But again, if we're going after like a limited budget, like Brad said, we would probably start with the manufacturers and just stick with them for now.
Yes, so if there be any other questions?
Yep. Can you speak a little bit to the limitation in Claim 1 about the desired fetal position range? Is that sufficiently definite as to what you're talking about there? Could you elaborate on where in your specification it gives more detail on that?
Yeah, I think, in our specification, we just say that there would be a range of what that could be. I guess, like with this exercise, there was no benefit of having some kind of inventor questions on, what could this desired range be? And that is for sure one we would have loved to ask an inventor of the several questions we had.
So when you're talking about fetal position, are you talking about the fetus growing within the chamber so that the chamber needs to be expanded? Or are you talking about like the fetus being somewhere in the chamber you don't want it to be and you move it somewhere else, or both?
So yeah, we drafted our specification to encompass both the aspect of the size of the chamber itself, as well as the repositioning of the fetus without having to actually like open up the chamber and physically reposition. So this is a very important aspect. Thank you for mentioning that.
Because one of the benefits of this invention is you need to keep the fetus below the fluid line, and that's particularly important. So we think that would be a useful benefit of the fetal position, would to be ensure that the fetus is positioned below that line at any point. And again, as Juan Guillo said, the growth factor as well. The fetus is obviously going to grow. That's the point of the system. So we want to make sure that we have mechanisms within there to allow for growth.
And I noticed that your dependent claim, where you further define the actuation device as the inflation chamber, you claimed the inflation chamber being, I think you used the word about or around the chamber. So did you think about an embodiment where the inflation chamber could be within the chamber instead of out around the chamber? Is that a design around that you considered?
I think that, yeah, we did talk about that with our coach, about that could be a possible design arounds. Again, I think that would be another great question for an inventor about if they're considering, putting it inside the chamber or outside the chamber. We're really not sure. And so we considered around for this one, but I think a great, if we had more dependent claims and we were limited to only 10 total claims here, instead of having maybe around saying within the chamber as well, that'd be a great dependent claim to add.
Yeah, I forgot to conclude the presentation, but we express our sincere appreciation for the honored judges and the NPADC organizing committee for this valuable opportunity. Please let us know if there's any more questions. Happy to answer.
Great.
All right, thank you so much.
Thank you, everybody. Appreciate it.
Thank you. So the University of Wisconsin Law School, you can either remain in the room or go to the adjoining auditorium. Thank you. Hi, everyone. My name is Tamika Obashan, and I'm the official timekeeper for this session. A few housekeeping items. Who will be presenting for the team? All three? Okay, wonderful. Okay, competitors, you will have 20 minutes to give your presentation to the judges. Judges, you will be able to ask questions during the presentation. The presentation time will not stop to answer questions. Okay, your time will be adjusted if there are technical difficulties during the presentation. The official time will be kept by me. I will announce a 2-minute warning when there are 2 minutes remaining for your presentation. I'll do the same for the judges. Okay, you will be allowed to finish your thought when time runs out. When your presentation is complete, you may remain in the room or go to the adjoining auditorium. Are there any questions? Okay, if none, you may begin and your time starts now.
Good morning, everyone. Thank you, judges and organizers of this competition, for having us here. We're excited to be telling you today about our application, Volume Adjustable Artificial Womb. My name is Ola. I will be starting by giving you an overview of the invention and talk about our search strategy and results. Rick will present our claims and our claim strategy, and Ross will talk about the detailed description and the figures. The invention is an extrauterine system that's intended to support the growth of a fetus or a mammal until desired development. The features of the system include volume adjustable membrane, here shown in yellow, that changes in volume as the needs of the fetus change. The change in volume of the membrane can be accomplished by inflation chambers, shown here, that inflate or deflate by receiving air or fluid. Strain gauge sensors make measurements of the membrane deformation, and these measurements are used then to adjust the membrane volume. Other features of the system include a fluid environment for the fetus, which can include amniotic fluid and perfluorocarbon. There is a port that connects the fetus to the external environment. For example, here, it connects the fetus to oxygen or nutrition. And finally, we have a waste removal system to keep the fluid safe for the baby. So for our search strategy, we performed our search with statutory considerations in mind. So first of all, these included identifying the patentable features of the invention. And second, we wanted to determine how broadly we may claim so that we may tailor our claim strategy to the needs of the client. For our first iteration of searching, we used a SPASnet, and we used broad terms. For example, we searched artificial uterus and many related variations. Among the relevant patents that we found were this one by Chirikov. And this one recites a system for supporting the growth of a preterm fetus, but this reference does not recite volume adjustable flexible membrane, an inflation chamber, strain gauge sensor, or perfluorocarbon. So we looked for these features in our subsequent searching to determine novelty and obviousness. In the next iteration of searching, we used the USPTO public search website. We found the classification code for incubator, and we used it with keywords and operators to narrow down our search results. In search number 4, for example, we were looking for the use of perfluorocarbon in an incubator setting, and we learned from the reference that we found that the idea of submerging patients in perfluorocarbon is not new, so we did not include this idea in an independent claim. Next, we looked at Google patents for forward and reverse citations and for find similar. We also prompted ChatGPT to find related patents, but at that point we did not find any publications that we haven't already found. Finally, we used Google and Google Scholar to look for non-patent literature, and we found this relevant publication that recites a volume adjustable membrane. However, it does not recite volume adjustment in response to membrane deformation, a plurality of inflation chambers, or strain gauges. This chart shows with a check mark which of the features we found in the references that we cited in our IDS. So the check mark indicates whether we found the feature or not in the reference. None of the references recited a sensor to measure membrane deformation, membrane manipulation in response to measurement of the membrane deformation, or strain gauges. One of the references did teach a plurality of inflation chambers, the Fisher reference, but that was in the context of inflatable luggage. Two of the references that we cited in our IDS were also cited by the USPTO after the regional round, and we reviewed all the other references that were cited by the USPTO and that are shown in this slide here. None of them recited a sensor to measure membrane deformation, volume adjustment in response to measurement of the membrane deformation, or strain gauges. So it was not necessary to amend our claims in light of these references. And next, Rick will talk about the claims.
Thank you, Ola. So we do have some extra slides here of the other references we've cited on our IDS in case you have questions for them later on during the question period. So I'll discuss the claim strategy. So after this search, we identified two main points of novelty. The first being the use of multiple inflation chambers, and the second being the use of strain gauges specifically. So the prior art only taught that single inflation chamber, which happened to be manually controlled, and it failed to teach the use of multiple chambers and that the chambers were controlled by the measurements of a sensor. And the prior art also focused on those pressure measurements, but failed to teach the measurement of a membrane property, such as deformation of the membrane. So combining these two, our main claim point of novelty that we focused on was the plurality of inflation chambers that's controlled by at least one sensor. But alternatively, we did identify that we could claim one inflation chamber controlled by a strain gauge, but in view of possible 103 objections, we thought the first was a stronger point to claim. But we would recommend that second point in a continuation. So we drafted 3 independent claims, the first being a system claim that claimed the chamber itself, the second being a non-transitory computable readable medium claim that claimed the software automation of our system, and lastly, a method claim that claims the use of our system. So this would target different infringers. The system claim would target manufacturers and distributors. The software claim could target those that sell the computer control unit separately from the chamber. And also our method claim would target users of the system and allow for theories of indirect infringement, such as contributory and inducement infringement. So moving into claim 1, we have an extrauterine system that comprises this membrane structure and then at least one sensor configured to measure a membrane deformation, and then a plurality of inflation chambers configured to manipulate that membrane volume, and it's dependent upon the measurement of the at least one sensor. So as you see here, we did make a slight amendment in our preliminary amendment to clarify that the membrane structures configured to encompass a fetus, and that's because we properly defined fetus in the specification. We have, in paragraph 15, we recite that fetus and prematurely born mammal can be interchangeably, and it's not meant to be limiting, and it also applies to mammalian and human fetuses. And additionally, in the specification, we provided a definition for membrane structure, where it's at least one elastic membrane, so that provides us a little bit of breadth there. And we also say at least one sensor, so we only have one sensor in this claim, and we introduce more later on. So we only included those elements that were necessary for this operation of expansion with inflation chambers, and we excluded everything else that wasn't needed for this into dependent claims, such as the processor, amniotic fluid, and other sensor types. And this claim set targets those manufacturers and distributors. So moving into the dependent claims, Claim 2 introduces the processor that's both configured to control the membrane volume and configured to control a supply of amniotic fluid. This does 2 things. It further narrows us to automated systems, which is novel in our view of the prior art, and to amniotic fluid, which ensures that our claim is viewed in light of artificial wombs and not read upon art that we weren't intending to practice in. And so Claim 3, we further introduce more sensors. We have multiple sensors now that are specifically strain gauge sensors. And this is that core inventive concept that we believe the inventor would be selling. And so it helps provide a claim that's direct on their product. And we also, due to our limited claim set, provide that each strain gauge is coupled to a respective inflation chamber, just to help provide some more limitations to survive future validity challenges and as a good fallback position in prosecution.
I have a quick question.
Yes.
On Claim 1, you recite that you have a plurality of inflation chambers and they're configured to manipulate a membrane volume.
Yes.
What does that configured to language add structurally to the inflation chamber?
It allows us to provide that purpose of what the chambers can do with not necessarily how they do it. And so that's kind of why we chose configure to there.
Okay, but does it impart any additional structure to the inflation chamber itself?
Not necessarily to the structure of the chamber, but it provides that it needs to be able to accomplish that.
Got it. Thank you.
So for our non-transitory computer readable medium claim, we introduced those elements of Claim 1 with additionally an inflation chamber system and a memory. And it has the basic steps of receiving a measurement, accessing a data set, and then determining a volume set point by comparing those two, which then is to send instructions to the inflation chamber system. So it's configured to adjust the at least one inflation chamber. And so here, these steps are only for one chamber, not the entire system, so it helps broaden that out. And also we introduced the inflation chamber system to enable functionality of the chamber because we can't send instructions just to the balloon. We have to send it to a system that would inflate the balloon. And again, we excluded those things that weren't required for this step. And for enforcement of this, and We did provide non-transitory language to meet the USPTO guidance on 101 to avoid fixation. And this would target, again, those sellers of the computer software.
So I had a question about the market for the software. In the medical device industry, you're frequently going to get FDA approval of the whole system, including the software that's controlling it.
Right.
And so I wanted to, did you think about how likely it was that there would be separate software sold in the market?
Possibly. We were mainly focused on if there was a computer system that could have a generic software for monitoring or that could perform these same steps, or even a generic that could enter that market, it would protect on that. Does that answer your question? Okay. And so these dependent claims are somewhat similar to the first, but they vary in scope. Here, Claim 6 is a little bit broader, as it doesn't require that relationship that we provided. And then Claim 7 is a bit narrower, which I think I might have skipped over Claim 4. But that provides the temperature regulation of the chamber. And so in Claim 4, we only had it for a single chamber. Here, we have it for every single chamber. And that brings us to our method claim. So our method claim is a method of adjusting a volume of a membrane structure that comprises placing the fetus within that membrane structure, measuring a property of the membrane structure that correlates to a size of the fetus, and then adjusting the volume of that membrane structure based on the measured property. So here we identify this slightly different novel concept of controlling the volume based on a physical property that relates to the fetus size, and that doesn't necessarily require the inflation chambers here, because that novel concept was not provided in the prior art. And we also made this a method of adjusting volume, as it may or may not be considered treatment, which could affect enforceability for collection of damages. And again, so yeah, as I said, we excluded those sensors and the inflation chambers. But for enforcement of this method claim, it's a little bit different, as we are targeting both direct infringers and indirect infringers. So for direct infringers, they could be doctors, nurses, those that are actually using this system. But it also could be in the agricultural setting for livestock, which we saw in the prior art for lambs and cattle, if it was used to artificially grow herds. And so that could be valuable in that space. But we do want to acknowledge that we are aware of 35 USC 287C, which would prohibit the collection of damages from medical practitioners performing a medical activity. There are different exceptions to that. If the device is patented, I believe we can still collect damages on it, but that would affect the possible value of this claim if the device wasn't patented. But we'd also have indirect infringement claims for those manufacturers and distributors of the system to target the users under theories of inducement and contributory infringement. And so for a dependent claim, we target, again, these novel concepts of bringing in those inflation chambers, and then also Claim 10 of the measuring properties done by a deformation, is measuring a deformation by the use of a strain gauge. So we would recommend a few future actions. We would recommend the applicant reach the full 20 claims for U.S. prosecution, bring in more novel features into those claims, such as the perfluorocarbon, the alarm features, and other sensors, and then pursue a continuing application for that other point of novelty that we identified before, and also recommend possibly doing a freedom to operate analysis to see where the client could land in this space. And with that, I'll hand it over to Ross.
Thank you, Rick. So going into this, we had the 8-page limit. So the first thing we did was just go through the list of approved fonts, and we picked out 12-point Arial Narrow to just get as much information per square inch as possible. Push the wrong button here, I'm sorry. Okay, now to get that written description support, we kept 112A in mind for enablement and implementation. And then we also kept in mind 112B and F, where we just defined key terms early and stuck to them. For our enablement strategy, so this is kind of what we were thinking about during the prosecution phase of the patent to ensure kind of broad claim coverage. We included alternative embodiments and support claim elements if 112F is applied. For example, paragraph 24 there, we have additional sensors that could be used, or paragraph 21 there, where we define a membrane structure and possible materials and thicknesses. And that provides support in case we have like continuation or we need to amend claims, so we can do that without introducing new matter. For 112A, we included detailed disclosures to create fallback positions. So that, again, gives us some flexibility during prosecution. But it also acts as 102A prior art to kind of prevent others from just designing a quick, easy design around. For example, in paragraph 22 here, we show that the inflation chambers can be positioned in various locations within the membrane structure. And then paragraph 26 outlines different functional outcomes to either increase or decrease the membrane's volume when inflated. So collectively, this level of detail just supports strong claims and just strategic IP protection. With that, we come to the figures. Now, the figures support enablement under 112A. We've already described how the plurality of inflation chambers operate, specifically their inflation and deflation. So the inflation chambers, they can expand or contract to adjust the volume and shape of the membrane to just demonstrate that the claims are fully enabled without the need for undue experimentation. Here we included an essential feature of the system, even though it's not novel or claimed, because we still need to ensure a faceta can understand how the full system works in context. To create the figures, we used PowerPoint to incorporate novel and claimable features like control systems and delivery components to just kind of visually demonstrate how the system connects as a whole. But we need to do more than just connect everything together. And that's where our block diagram comes in. Yeah. So this kind of illustrates the system's architecture, including like the processors, memory, sensors, and pumps. We enable claim language around that non-transitory computer medium and automated sensor control. We also included flowcharts outlining the logic of the independent claims. On the left is the flow for the non-transitory medium claim, kind of showing how the system processes that sensor data to control inflation chambers based on a strain threshold. And on the right, we have the method claim, which covers placing the fetus in the system, supplying oxygen, nutrition, and adjusting the membrane volume based on sensor feedback. Collectively, these flowcharts are intended to convey the claimed functionality and help ensure that the public benefits from the present disclosure.
I have a quick question.
Yeah.
I noticed that your non-transitory medium claim flowchart includes a last step of adjusting the inflation chamber to the determined set point, but that your claim 5 doesn't include that step. So it seems to me like you're missing kind of the practical application piece. How would you respond if you were to get a 101 rejection on claim 5?
That's a great question. Rick, do you want to?
If we were to get a 101 rejection, we'd state that it's directed to sending those instructions, and that's the technical solution to the technical problem, is having those specified instructions determined from a membrane deformation that then inflate and deflate that chamber. So there's that physical action that's being done by those instructions, and it's different than just an abstract idea of providing an environment for a fetus.
With that kind of concludes things. We would like to thank our coach, Paul Perrins, USPTO for hosting this amazing event, and just the University of Minnesota for getting us here. We open this up for questions then.
You had mentioned in your feature actions about the freedom to operate. If the inventor were to come to you to say, what does that mean? Or you had an investor, how would you advise or what would you respond?
Yeah,
and
so
how would you use the freedom to operate?
So freedom to operate, we'd first explain that patents are exclusionary rights. And so other people might have patents that would exclude what we include, while our patent might exclude additional features that we found novel and was granted a patent on. And so we first need to determine if we'd be able to sell a product without infringing on somebody else. And that analysis would provide them with that information.
Can you speak a little bit to the prior art you found? It may have been the non-patent literature that showed the inflation chamber and how you could distinguish over like multiple inflation chambers. How is that not obvious in view of a disclosure of a single inflation chamber?
Sorry. Ways to go. There you go.
Well, first of all, as far as we could tell, the way that they inflated and deflated this chamber was not automatic. They made a reading and then they manually did the adjustment. So, I mean, in my view, it's not obvious how you would do it in an automatic way with and even just measurements that are of a different type. They're strain gauge measurements.
Yeah, so in our independent claim 1, we do have a sensor configured to measure membrane deformation, I believe.
That's correct.
And so that's what we definitely use to get over this prior art reference beyond that single inflation chamber to multiple being obvious.
On claim 8, suppose you got a rejection along the following lines. You're might be under 101, might be under 112, a lot of overlap between those. That essentially what claim 8 is doing is claiming the solution, because you're measuring a property and then you're adjusting the property, but you're not giving any specifics as to how that's accomplished or what the measurement criteria are.
Yeah, so our response to that would be most along the lines of the Diamond v. Deere case, where this use of an abstractive idea of using a mathematical equation to then take a step of producing an article is essentially what we're doing here, where that measuring the property itself is what we believe is novel, the membrane structure correlating, or deformation, or a property correlating to a size of the fetus essentially. But then that step of adjusting that volume, which is our technical solution to make a better environment for the fetus, is analogous to the Diamond v. Deere case of using this measurement to produce something that's now useful and new and better in view of the other art.
And suppose the examiner cited back to you US v. Morse and said you're claiming all adjustments to the size of an artificial womb.
I'd respond that we're not claiming all adjustments here. We're claiming making that adjustment based off of a membrane property. And that's the novel point. We're not just claiming adjustments for as the fetus grows, we increase in size. We're making that adjustment based off of those conditions of the membrane.
You may have already covered this, but can you speak a little bit to the amendment in Claim 1, the very first limitation?
Right.
What the thinking behind how that amendment came about?
Yeah, so you can see it right here. We made it throughout our claims. When we were looking at it, we had a few questions during the regional round where they're like, why would you include that if you have it defined in your specification? So that prompted us to look at it further. And when we looked at that or, we were a little concerned that it may or may not be clear if it could do one or the other or both. And so we just decided to eliminate that ambiguity and just simplify it in our preliminary amendment and state that we weren't narrowing or changing the scope of our claims because of that definition, and we were just clarifying it for prosecution.
What about your amendments in dependent claims 2 and 4?
Oh.
So what were you addressing in removing means and using the specific term via?
Yeah, so there we never meant to invoke a means plus function interpretation. And so that was, again, just for clarity. When some practitioners see means, it raises a flag that we didn't intend to raise. And so a definition of by means of is or via. And so it's essentially the same word, and we just wanted to make that clarification and avoid raising means plus function application when it wasn't intended.
Are there any limitations in your claim where you think they do invoke 112F?
I'd say no.
Okay.
But I do know, just being candid, the method claim is a little bit broader, and so I could see some of those steps invoking 112F and bringing in some of the elements of our specification. Yeah, thank you.
Thank you, University of Minnesota. All right, good afternoon, everyone, and welcome back. Hope you all had a great lunch, and welcome back to our virtual attendees as well. Up next, we have the University of St. Thomas School of Law, and I will begin with my timekeeper spiel. Okay, my name is Tamika Obashan, and I am the official timekeeper for this session. A few housekeeping items. Who will be presenting for the team? Will all of you or one of you? Oh, wonderful. Okay. Competitors, you will have 20 minutes to give your presentation to the judges. Judges, you will be able to ask questions during the presentation. The presentation time will not stop to answer questions. Judges will have 10 minutes, or roughly 10 minutes after the presentation has concluded, to ask additional questions. Your time will be adjusted if there are technical difficulties during the presentation. The official time will be kept by me. I will announce, as you heard one of the judges already say to you, the 2-minute warning. When you have that amount of time remaining in your presentation, I will give everyone, also the judges, a 2-minute warning. You will be allowed to finish your thought when time runs out. When the presentation is complete, you can either remain in the room or you can go back to the adjoining auditorium room. Now, are there any questions? Okay, if none, you may begin and your time starts now.
Hello all, thank you for being here. This is our USPTO Patent Drafting Competition 2025 submission. We are the University of St. Thomas School of Law in Minneapolis, Minnesota. I am Sabrina S. Despacia.
Eric Osborne.
I'm Alex Singer.
Just a roadmap about what we'll be talking about today. First, we'll go through our invention disclosure, then we'll talk about our prior art search, into our prosecution strategy, and then our specification drafting considerations. 1 in 10 infants are born prematurely in the U.S., and premature birth is actually one of the leading causes of infant mortality. So to combat this issue, the inventors designed this system to improve infant survival rates by placing a premature baby within this artificial womb system so that they could continue to develop just as a natural baby would in a natural womb. For our prior art, we did a 3-step approach. First, we talked about different invention elements and decided to do independent searching based on those invention elements. So things like biocompatible material, inflation chambers. Then we came together as a group and we searched across multiple databases. Then we wanted to incorporate some keyword searching with class searching. So we further defined our search terms and we combined, we used the IPC code, which is that A61G11, and we also searched the UPC 622, which is incubators, and then that A61G11 was baby incubators. From our results, we created this colorful chart, which is basically a 4-point color scale that is a level of severity, or similarity, excuse me. So red in this case would be prior art that is very closely related, things that would be almost an exact match between our invention and the prior art. Yellow would be things that are somewhat related, so things that have similar features and a similar purpose, but aren't exactly the same. Green is things that are minimally related. This would require a little bit of mental flexibility to see the connection. And then blue is just not present, so was not included in the prior art. And when we laid out this in an organizational way, we wanted to determine which inventive element was going to be our focus, and it was very clear that the inflation chambers was the only inventive element that did not contain red, and thus we wanted to focus our disclosure on the inflation chambers. We did that same thing with the USPTO disclosures that we received after the first round of the competition, and very similarly, we saw that the inflation chambers were still the only inventive element that did not contain any red. So we continue to gear our kind of focus on those inflation chambers.
During our prior art search, we ran into this figure from Cherkov along with 2 other patents from Cherkov. As you can see with Cherkov being on the right and our invention disclosure figure being on the left, it's pretty clear that the invention disclosure took some inspiration from Cherkov given the art design and the way that the features are depicted. But it's key to note that Cherkov doesn't present any inflation chambers within its figures, within its spec, nor its claims, nor in the other 2 patents. Going into our prosecution strategy. So an overview of our claim drafting strategy, again, due to the prior art, we decided to focus on the novel element as being inflation chambers. For that reason, we decided to make all 3 of our independent claims focused around these inflation chambers. We decided against focusing on a different element as we felt that it would be less valuable to the patent itself, because it would require the claim to be extremely narrow to get around the prior art that we had been exposed to. And overall, it would take away an opportunity to better secure the inflation chambers. The reason why this element is so important is that it provides granular control over the enclosure of an artificial womb system so that it better emulates a natural womb. As typically a natural womb would fluctuate in size, expand and contract, depending on a multitude of external and internal factors for the fetus's benefit. And as neither the element of inflation chambers nor its specific function within the artificial womb it can be found in any prior art, we found it to be very commercially and medically valuable to the patent to make sure that they were secure. And to do that, we focused on securing the structure of the inflation chambers through 2 apparatus claims and the function of the inflation chambers in the system through a method claim.
So as Alec was just talking about, those the 2 types of claims we have are apparatus and method, and our apparatus claim in terms of enforcement could be used, or also in terms of potential licensing opportunities, used against manufacturers, any sort of healthcare manufacturer that's engaged in this space, who could then sell to either a seller or a third-party distributor, who would then sell to an end user, which would be hospitals, research institutions, or anyone else engaged in this space. And our method claim is a method of use and is therefore directed towards users. So while our original claims were patentable, we made some amendments in view of the broader USPTO disclosures, as well as feedback we received from judges earlier in the process. So I'm going to start with some substantive changes we made. So claims 9 and 10, which claim 9 is a method claim, and claim 10 is a dependent method claim on that independent claim 9. And in claim 9, we added the word automatically, and in claim added the words real time. And the purpose of these changes was in response to 101 concerns related to a method of organizing human activity. And this is to further clarify that these claims are not something that could practically be done by a human, and that it would not be possible to either automatic or in real time mimic a natural womb as described by the method in these 2 claims. We also canceled claim 8, which was an independent system claim. This claim was essentially a picture claim. It was very narrow. And we added new claim 11, which contains a different scope of inflation chamber, that limitation, and then also adds and modifies some other language in that claim. And the purpose for this was in view of the prior art disclosures provided by the USPTO, as Sabrina was talking about previously, we felt that it provided more value to the inventor to have different levels of scope and different ways of claiming the specific inflation chamber limitation than having a narrow picture claim at this stage in the prosecution.
couple clerical changes I just want to note. So claim 1, very simple, added a semicolon to just further specify what was being said in the claim there. And then claim 4, just similarly, just to further clarify this group of consisting of, say, liquid, gas, and semi-solid, as opposed to fluid, gas, and semi-solid, since gas and liquids are both fluids. And this was just, again, to further clarify what we were trying to specify in this claim.
Quickly going over claims 1 and 11, just them being compared, because as Eric mentioned, claim 11 is very similar to claim 1, but the main differences are in claim 1, we claim that the enclosure is made of a biocompatible material. We get rid of that in claim 11 to help broaden that claim. In claim 1, we claim a plurality of inflation chambers. In claim 11, we claim 1 or more inflation chambers, again, to help broaden it. And then in claim 11, we added to mimic a natural womb to narrow the scope of the prior art that would then be compared to that claim to try to make the scope just about artificial wombs and neonatal systems, just to make sure that while we make it broader, that we're narrowing the scope.
So is it your view that by adding this so as to mimic a natural womb, you've somehow breathed life or meaning into the preamble so that it narrows the claim? Because the body of the claim is really just an enclosure and an inflation chamber operable to change the inner volume of the enclosure. So really the only thing tying this device to the actual intended use of using it to mimic a natural womb is that so as language. So do you think that's enough?
Yeah, I would argue that it's enough to do that, as well as provide an additional limitation within the body of the claim as well.
With that, going into claim 1. Claim 1, an apparatus claim, focused on securing the structure of surrounding the inflation chambers. In this, we claim an enclosure, an inner volume, and a plurality of inflation chambers. We felt that these parts were core to the structure of the inflation chambers and adequately described the inflation chamber's place within the artificial room structure as a whole. As you can see from the figure here, we have highlighted the enclosure, the inner volume, and where the inflation chambers would be based on the language of the claim. We also felt that this language of the claim did well to secure the structure given the light of what we found in our prior art search. Speaking of, going into our prior art, we have a snippet here from the table that Sabrina went over. Here we have flake, which we bring up just because there's that center area that is an enclosure that a baby would be put into, that then these rings are placed down to clamp the outside area of the enclosure to limit the size in which it can expand to, which is why it is here. However, our invention features inflation chambers within its claim, so instead of these solid flat rings. And so overall, we felt that it didn't infringe on what we have claimed. And then also, this was another piece of prior art, Delbrecine. The part we are focusing on here is that smaller of the two rings, which inflates and expands the opening of that birth canal, so then the baby can be transferred from the womb to a separate enclosure. Afterwards, that enclosure is closed off, and this two-ring system is then discarded. And here, the difference that we have compared to our claim is that our claim features a plurality of inflation chambers. If you were to reach and try to describe the ring as an inflation chamber, we have a multitude. And then also just the function itself is very different with how this inflation ring deals within this invention compared to the inflation chambers of the invention we're patenting.
One quick question. On claim 1, your claim recites that the inflation chambers are arranged about the enclosure. What does about mean? We wanted to make sure to leave room for possible embodiments. So within the specification, we talk about being within the enclosure as a part of the enclosure or outside of the enclosure. So we just wanted to make sure that there was room for other embodiments depending on what people would make to either try and copy or other possible infringements.
So for our next independent apparatus claim, which is our new claim 11, just to highlight a couple elements here, similar to claim 1, we have an enclosure, and then in this claim we're claiming 1 or more inflation chambers, and then, as has been mentioned, so as to mimic a natural womb. And I'm just briefly going to touch on how this claim relates to both Delbecine and Flake that Alec just covered. So again, with Delbecine, the invention is not directed or does nothing to mimic a natural womb, and is really a transfer device. And then for Flake, again, we have these solid rings on both the top and the bottom, which are not inflation chambers in any sense. And while they apply pressure, again, have no chamber to them, essentially. And I'm also going to touch on Way, which was both included in our IDS and then also what was provided to us by the USPTO, which is we have this larger outer chamber, this egg-shaped chamber, and then an inner chamber that the baby is placed in. And the specification does describe the inner chamber growing or expanding as the baby grows, but there is no indication about how that's happening or even if you describe this outer chamber as an inflation chamber, it's not operating in any way on the inner chamber to change the size of the enclosure that the baby is in, which is what differentiates claim 11 over that.
Before you move on to the method claim, kind of going back to a previous question on independent claims 1 and 11. So you responded with if an examiner were to present other prior art that was not necessarily, let's just say, in this for uterine, right, a uterine system. Okay. They were to indicate to you in a subsequent office action, say a final office action, saying that they believe the preamble is intended use, that so as to mimic
a natural womb.
Yeah. Natural womb is also intended to use. How would you respond to that then? If obviously they're taking a strong position, as is likely the case, how would you respond either with an amendment to these claims or further arguments?
So just to clarify, so you're saying it may appear outside the scope, but they're claiming that it is within the scope of mimicking a natural womb? Or that the argument's that it does mimic a natural womb?
They're reading it broadly to the claims as an apparatus, taking out all the configure to language because it's a preamble intended use, and then they're looking for an enclosure defined by an inner volume, and then they have a plurality of inflation chambers. So they're taking it very broadly.
Yep.
So how would you address that if they're
So I think for part of our strategy, so for claim 2, which is a dependent claim on claim 1, for instance, we further describe independent operation of the inflation chambers, and I think that would be our first, if we were going to amend in a continuation or RCE or wherever we were in the process, that would be my first idea, to add that limitation.
So actually to follow up on that, with that strategy, would your goal then be to sort of accept the examiner's understanding of the claim that it would encompass something outside the medical context?
Without seeing office action or exactly what the argument was, I think maybe my first step would be to talk with the inventor to see if they wanted to delay prosecution or potentially have something that could have us, if it's a final office action, I guess, for example, if we needed to go through an RCE or depending on what their opinion was on how fast they either want to get allowance or something. But yes, the point I made to him would be conceding that it's a broader claim in that way.
And why don't you think it would be better, or tell me if you think it would be better to amend so as to clarify that it is, put a structural limitation on there or some other limitation on there that does limit the scope to the context of a preterm infant?
I think that'd be a perfectly valid solution and could also, take some of the preamble and put that in the body, or as we have like biocompatible, again, depending on the specific prior art piece, how we could get around it. I think that would also be something that we would consider,
All right, then moving into our method claim, really just describes how the inflation chambers themselves are working. So what we have here is we have a control value that's received that's indicative of a pressure within the enclosure, really on the interior surface of the enclosure. And based on that control value, we are adjusting automatically the working agent that's placed within the inflation chamber to better mimic a natural womb. In terms of our prior art, we first have Restraighten, which is a strain gauge bladder system, which is a piece of material, twine, string that's placed on the outer surface of a bladder. And the bladder is, or the twine is manually adjusted at those notch points to allow the bladder to grow or increase in size as the mesh network grows and increases with those manual adjustments. This doesn't defeat our novelty though, because first, there's no pressure, there's no indicative pressure, there's nothing that's being measured here, and two, there's no working agent. It's just a manual adjustment of a piece of string or twine, whatever this would be used of. And then our second piece of prior art is again Flake, which Alec and Eric were talking about, and those two restriction rings, placed on the top and bottom, they're manually adjusted, they're manually lifted, they're only allowing the enclosure, within to grow. There's no working agent here. It's just a piece of material.
So briefly, just going to highlight a couple things on our overall claim drafting strategy. So most of our dependent claims are focused on other aspects of the inflation chamber as described in the specification, in the invention disclosure. So for example, claim 3, claim differentiation, basically the point of that claim was to say that our independent claim doesn't have to have a working agent in it. So for enforcement purposes, if the manufacturer doesn't have a working agent while they're shipping that in the inflation chamber, provide us an argument with claim 3. And then the next 2 points here are similarly just other elements that were described by the inventor as being attached or part of the inflation chambers in the invention disclosure.
And briefly, just touching on the drafting considerations, obviously our primary goal was to meet 112 requirements, so describing exactly how the inflation chambers work within the system and how they interact overall with the enclosure and the inner volume, and just how everything that is functioning within the actual invention. Describing these umbrella terms like biocompatible and life-sustaining fluid, which were mentioned within the invention disclosure, and just making sure to carry over the examples that they gave for those terms. And then also to cover other embodiments for inflation chambers, such as the orientation, the number, and the sizes. And then also sensory collection method, as that can be done. You can sense temperature and pressure in a multitude of different ways, so just covering our bases to show that we thought about it. And then everything from the invention disclosure and the claims as well.
Questions?
I have a question on claim 9, the method claim. So just to make sure I understand it, the first step is receiving a control value indicative of a pressure of an enclosure. So that's the enclosure with the baby in it, correct? Okay. And can you just run me through kind of your thought on why you focused on pressure as opposed to some other way of measuring what was going on, like maybe using a strain gauge, for example, or something other?
Yeah, so the whole goal of this invention was just to better mimic a natural womb. So a baby in a natural womb, it moves and puts pressure on the surfaces of a womb. That's how it works. So we chose to focus on the pressure of the outer surface just as a baby would within a mother's womb naturally. So we really would just try to emulate as the best way that we could mimic that natural womb. Kind of a simple answer.
Suppose you got an indefiniteness rejection for the phrase mimic a natural womb. What would your response be?
So I think first, within our specification, we describe, at least us also in the background, but throughout the disclosure, kind of what we talk a lot about an artificial womb and having that be the baseline to compare to the mimicking standard or what the level of application would be. And so I think I would first respond that the specification provides adequate definition to, if the concern is about the level of mimicking, if that's what you're getting at, that the artificial womb would describe that language within the natural.
If you had to make an amendment to pick a parameter that you were going to mimic, what parameters would you want to claim?
Based on what was described with the inflation chambers and their actual effect on the artificial womb, probably mimicking the structure of the womb and its natural ability to expand and contract.
On slide 12, you don't have to necessarily scroll back, but in talking about your claim drafting strategy, you had considered, I guess in terms of the types of claims you were choosing, you were looking at enforcement. And I assume with regard to licensing, that would also be somewhat of a similar analysis.
Yes. Correct.
If the inventor were to come to you, let's say you got these claims, let's say as is, or let's say slightly narrower, what subject matter would you focus on in building out a patent portfolio for the inventor? In other words, like what are kind of the secondary, tertiary, or combination of elements that you think based on prior art, maybe looking at other owners of patents in this area, how would you advise the client or the inventor?
So you're talking about the context, like if we were to file another, like a continuation or
Right.
some other form of...
Continuation in part.
Okay, sure. I think, so as we talk about the prior art, there was a decent amount of overlap with a lot of other inventions. I think specifically around the, as we talked about the way that the temperature or pressure communicates with the inflation chamber, I think maybe that would be an area where you could expand upon to talk more about that interaction as opposed to specifically just the inflation chambers.
For claim 6, what do you think that the additional limitations are adding in terms of validity and overcoming prior art objections?
So for claim 6, the main, in this dependent claim specifically, I think for prior art objections, the things you're raising there, claim 2 and 3 are more directed towards that type of differentiation. And then for claim 6, it's primarily more to just have some coverage around what the inventor was describing as part of those inflation chamber components, if that makes sense, as less of a pure enforcement strategy. I think that in that context, if that makes sense. So more focused on having elements that the inventor finds important as opposed to specifically validity and for that specific claim. Would be how I'd answer that question.
My name is Tamika Obashan, and I'm the official timekeeper for this session. A few housekeeping items. Who will be presenting for the team? Will all of you be presenting? Awesome. Okay. Competitors, you will have 20 minutes to give your presentation to the judges. Judges, you will be able to ask questions during the presentation. The presentation time will not stop to answer questions. Judges will have 10 minutes or so after the presentation has concluded to ask additional questions. Your time will be adjusted if there are any technical difficulties during your presentation. The official time will be kept by me. I will announce a 2-minute warning when there are 2 minutes remaining in your presentation. I'll do the same for the judges. You will be allowed to finish your thought when time runs out. When the presentation is complete, you can either remain in the room or go to the adjoining auditorium room. Are there any questions? Okay, if not, you may begin and your time starts now. Can you?
Hello. Hello. We are here to present an extrauterine support system and method representing inventors James Wilson, Sean Doherty, and Dung Olsch. I'm Kylie Snow, and I'm here with my colleagues Tanner Murray, Ian Shaw, and Alessandra Gualtieri. So here's a brief outline of where we're going to go with this presentation. So we received the Figure 1 image below from the invention disclosure from the inventor and modified it to the Figure 1 image above, with the elements that we felt were key points of novelty but were excluded from the inventor's initial figure. So the elements we added were environmental sensors, strain gauge sensors, and inflation chambers. The following slides present Claim 1 and Claim 7 enlarged in case there are any questions. And we have also provided a hard copy of our presentation for your convenience. So for our search strategy, we began by identifying keywords and key sections of the invention. We used these to create Boolean string searches and used these in the USPTO patent search system, Google Patents, and eSpaceNet. We also searched non-patent literature. From the initial patents we found, we conducted forward and backward citation searching, as well as a review of their prosecution histories. From our initial patents and from the USPTO classification definition, we found 2 classifications to continue searching in the USPTO patent system. When we conducted our prior art search, we separated out the references based on their relevance to our system and method claims. Here, these prior art are related to our system claim. So the main reference we selected was the Cherikov patent. The Fasihi patent application was relevant to sensors. The Flake patent was relevant to a membrane setup, and the TUE patent was relevant to a chamber setup. From the prior art provided for the finals round here today, we used the same system of organizing. The Cooper patent was relevant to a membrane setup. The Sitzman application was relevant to reservoirs and catheters. The Fasihi patent was relevant to a chamber setup. The Cooper application was relevant to perfluorocarbon liquids, and the Fuchs patent was relevant to gas exchange. The prior art relevant to our method were the Flake patent, which was deemed a main prior art under this point, the Fasihi application, which was relevant to a method of using sensors, the non-patent literature by Dr. George on artificial womb technology and AI use, and the Cherikov patent application, which was relevant to AI and network use in an artificial womb.
So rather than just analyzing the prior art piece by piece, let's take a step back and ask, what was brought to us? What did the existing references teach? Could they be combined in an obvious way to capture what our inventors disclosed? And if not, how can we express that best in our claims? At first glance, the inventor's disclosure described an extrauterine system, or an artificial womb designed to support premature infants. But as we examined it further, it became clear that this was more than just a passive life support machine. This was an advanced self-sustaining system that actively monitors, learns, and grows with the infant. In distinguishing the prior art, we did initially recognize some similarities in the figures disclosed in the Cherikov references. And being aware of those similarities, we wanted to keep in mind the importance of highlighting how our inventor's system was a progression from this particular reference rather than a reiteration of it. Considering the prior art generally, we recognize that the Cherikov and Flake patents covered artificial womb systems, but lacked sensors coupled to inflation chambers. The Fasihi and TUE applications discussed methods for regulating artificial womb environments, but did not integrate sensor-driven automated environmental control. So we structured the client's claims to have the breadth necessary to be enforceable, narrow enough to avoid written description issues, and strategically drafted to prevent easy design arounds. Our core claim features emphasize sensor-driven adaptability, including first, strain gauge sensors coupled to inflation chambers, and a mesh network of environmental sensors. Each additional cited prior art reference is also distinguishable from our invention, clarified further by our amended claims. First, Cooper's elastomeric seal significantly differs from our biocompatible membrane, as our inventor's membrane is specifically designed with uterine elasticity and shape memory characteristics. Cooper also emphasizes perfluorocarbon as novel. We use PFC only in a dependent claim and for descriptive purposes without relying on it for its novelty. Finally, Cooper's alarm system is limited to fetal heart rate and pulse oximetry, while our inventor's system has comprehensive alarms to monitor broader physiological conditions. Looking at the Cherikov AI reference, there the AI retrospectively manages medication, while our inventors incorporate AI that proactively forecasts growth and dynamically adjusts the conditions. Cherikov also employs standard networking, while our inventor's innovative mesh integrates strain sensors and adaptive inflation chambers. Lastly, the Sitzman reference focuses on catheter systems, which were explicitly removed from our claims in the amending process. So in sum, a person of ordinary skill in the art would not have found it obvious or had sufficient motivation to selectively combine these references in a manner that achieves what it is our inventors achieved.
Claim charts are a useful tool that can be used during patent drafting and litigation. For example, this claim chart is configured to compare Claim 1 with the primary references supplied by the USPTO, including the Chirikov patent and the Flake patent. Here, the red boxes represent features that an examiner will likely consider to be taught by the prior art, and the green boxes represent features that are strong points of novelty. This allows for an effective analysis of the prior art and helps us to ensure that we write proper claims that are novel but not overly narrow. Shown here is a claim chart designed to compare our method claims, specifically Claim 10 with the prior art. This claim chart contrasts Claim 10 with the non-patent literature by Dr. George and the patent application by Chirikov. Here we see that this claim chart again illustrates at least 3 points of novelty over the prior art. It's also worth noting that the non-patent literature merely suggests the potential benefits of integrating AI into artificial womb systems rather than disclosing an actual invention or implementation into such systems. Additionally, the Chirikov application claims relate specifically to AI management of fetal physiological parameters rather than broader whole womb management as in our claim.
The first amendments we made to our claims were to ensure proper antecedent basis. We then made amendments where non-novel elements that did not impact patentability were removed from the claims, as our original claims were unnecessarily narrow. We removed the reference to the flexible chamber with the hinged opening because we felt that flexible chamber was duplicative of the elastic membrane, and the hinged opening reference was an unnecessary limitation. We also removed the reference to the catheter system because this is a standard element in the art that was also unnecessary limiting. Lastly, we restructured the organization of the elements in the claim in order to improve the understanding of operability of the invention. Overall, we did not need to amend claims to get around prior art, as our points of novelty remained even with the new cited art. From our dependent claims, we removed redundant description with the independent claims. When amending our method claims, we first ensured proper formatting when describing claim elements. We then made amendments to improve clarity of the method steps. Generally, the verbs in a method claim need not be phrased in any particular voice or tense, as long as there is no ambiguity in the requirements of Section 112 are met. However, in the regional round, we received advice from a judge that our original method claim had a risk of having some of the elements being read as system or apparatus elements. And one technique we could use was to use gerundial phrases to describe the claim elements. As for our dependent claims, we removed duplicative elements with the independent claim. When drafting our claims, we used two types of dependent claims. Ones that were meant to further define the independent claim elements, such as Claim 3 and Claim 5, and ones that were meant to focus in on the novelty of the independent claims, such as Claim 6 and Claim 8. When making our claim amendments, we decided to remove a defining dependent Claim 5 and replace it with a new Claim 11 in order to focus in on the novelty of the mesh network. We determined that this new Claim 11 would provide greater protection for the clients because part of their invention is to provide redundancy in the case of a sensor failure.
Now, moving on to Section 101, with respect to Claim 1, there's virtually no risk of a 101 rejection. We claim physical elements that perform functions and results, which is patentable subject matter. As seen on this slide, our method Claim 7. These are unlike the claims that were presented in Alice and Mayo, for example. Unlike those claims that were directed to well-understood, routine, and conventional activity, our invention focuses on the sensor hardware and that specific hardware for operation of the system. Here, the sensors are not sensing human conditions. They're sensing conditions that are physical to the system itself. And not only are these sensors obtaining data from a machine, not a human, the system is reacting and carrying out these tasks such as inflation and environmental condition changes such as flow rate and circulation of fluid. Therefore, these are tangible components that perform specific functions and achieve concrete results. Therefore, these are not abstract ideas, nor are they natural phenomenon. And then with respect to enforcement on our method claim, we could pursue direct infringement against entities implementing this method. This was established in the case NTP versus Research in Motion. There, a method claim is directly infringed only by one practicing the patented method. Therefore, a direct infringer here would be a hospital, research facility, or business that implements this technology. Additionally, we could pursue contributory or induced infringement against manufacturers who place these systems in the stream of commerce with knowledge of the patent, and as stated in Section 271C, is also not a staple article that is suitable for substantial non-infringing use. Moving on to Section 102 and 103, so with respect here, our review of the prior landscape, while it reveals that certain elements of our invention appear in isolation, their specific combination represents a non-obviousness advancement. So again, our primary reference, the Chirikov patent, disclosed the artificial womb concept. However, that patent and the additional Chirikov application fails to teach an integrated mesh network of environmental sensors that are distributed throughout the flexible chamber, and a system of strain gauge sensors working with inflation chambers to create this dynamically responsive environment.
Do you think you could have gone even broader with Claim 1, possibly saving the mesh network of environmental sensors for a dependent claim?
So when we were drafting Claim 1, our thought process to minimize any sort of non-final office action, final office action directed around the patentability of that claim, the independent Claim 1, we added multiple elements in to highlight the novelty of this invention. And then our decision to do that was like forward thinking, which we'll also address in a later slide, about any continuation or divisional applications based off of or directed towards the different components of the actual system.
I had a similar question, but related to the inflation chambers and the strain gauges. Your prior art search revealed that both of those were novel, so why not have separate dependent claims targeting each of those?
If I understand your question correctly, dependent claims solely referring to those?
Oh, no, excuse me, sorry. Independent claims, meaning where the point of novelty is just the inflation chamber or just the strain gauges.
Your Honor, yeah. Additionally, that was our same thought process. We would leave that for a divisional or a continuation based off of what our inventors would, like future forward thinking, what our inventors would want. And we wanted to really focus on having a claim that would, as presented, be patentable. So the other, additionally, the other references, so the Fasihi one, that one disclosed environmental sensors, but lacked the integration of the mesh network architecture. As stated before, the flake reference, that one teaches membrane materials, but doesn't contemplate the dynamic response capabilities that our elastic membrane provides. And then the TUE reference describes a chamber design, but lacks the integration with the strain gauge sensors and inflation chambers. The Cooper application references the PFCs, which we don't include in our independent claim, and as seen in our amendments, we removed the catheters, which was disclosed in Sitzman. And as for the Fuchs patent, we do not use a gas exchange system or a system that is anyway related to their gill system. And so what makes our client's invention and the claims non-obvious is not merely the aggregation of these elements, but how they work together to create this adaptive system that responds to fetal growth and needs in real time.
In addition to the system claim, our team decided that a method claim should be presented because the inventor provided teachings and disclosures supporting the method for regulating the extrauterine support system environment. Distinguishing our invention from the George non-patent literature and the Chirikov AI method, our method is directed to the whole extrauterine environment. In addition to teaching a method for regulating the whole environment, our claims also include sensor networks, and these networks are an improvement over traditional sensor systems as described in the Chirikov application. Traditional sensor networks often use a star or tree topology where nodes communicate directly with a central node or gateway, and this central node is responsible for collecting data from all the sensors and forwarding it to a remote location. This configuration is less reliable because the failure of a central node or even a sensor can disrupt the entire network. Mesh networks, or mesh sensor networks, as described in our application, use a mesh topology where each node can communicate with multiple other nodes. This allows data to be relayed through intermediate nodes, creating multiple data paths to the destination. And this configuration is more reliable due to its data transmittal redundancy and self-healing capabilities.
Is the mesh network, it seems to me from reading your specification that the environmental sensors are mesh networked, but are the strain gauge sensors mesh networked as well?
Yes, Your Honor.
Okay.
For example, if a node fails in the strain gauge mesh network, data can be rerouted through alternative paths, and this ensures continuous communication. And regarding the AI element, the Chirikov application AI only teaches for medication management and uses vital sign readings to administer medication. The method disclosed in our application teaches and discloses control of environmental conditions and regulation of the whole extrauterine system. Further, Chirikov focuses on retrospective pattern recognition for clinical decision support, while our claim implements a predictive learning model to forecast future environmental conditions and preemptively adjust the artificial wound settings, and emphasizes a forward-looking trend identification and automated system corrections. Additionally, while theoretically permitted, we did not draft a medical procedure claim due to the limitation of remedies set forth in the medical liability exemption of 35 U.S. Code, Section 287C, which generally bars damages and injunctions for medical practitioners who infringe a medical or surgical procedure patent.
Did you find prior art directed to a mesh network in other medical devices?
No, Your Honor, we did not.
You mentioned the central node. Just want to kind of get to your thought process on your method claims. You're drafting your method claims. So you're referring to the central node. Is that correlated or is that represented by the control unit within your claims?
No, the mesh network works and communicates with the processor. The central node is referring only to traditional sensor systems and how they operate.
Okay, so in drafting the claims, your method claims, I noticed that for any method steps, you primarily focus on the control unit as the structural element that's performing that step. For example, in Claim 7, you talk about evaluating by the control unit, automatically adjusting by the control unit. But the transmitting step doesn't have a structural element associated with it. That seems to be in some of the other method steps, with the exception of Claim 8, where you did talk about the transmitting step from one of the sensors. So was there any thought process to why some method claims had structural elements associated with the method step and others did not?
It could be both the control unit or the sensor units of the method claims that are doing the transmitting step.
Okay.
All right, just so for the sake of time, if there are any questions with Section 112 afterwards, I'm happy to answer those. I just want to highlight real quickly the one or more processors. So in our drafting and our research, we found a Federal Circuit case, Salazar versus AT&T Mobility, and the reason we didn't use A and then said or the microprocessor is we did not want to limit ourselves to the claim being interpreted as only one microprocessor being required to perform each and every step of the invention where it's used.
So in regards to our drafting strategy, we used both system and method claims to maximize invention protection and target specific commercial applications. So we drafted system claims to target medical device manufacturers, healthcare institutions, and system integrators as they target direct infringement and protect the physical apparatus and components of the device. And we used method claims to cover the invention steps and ways of performing them, as well as the operational aspects of the invention. And by including both system and method claims, we have a comprehensive patent strategy that gives the inventor flexibility in enforcement options, allowing them to choose the best tool for commercial applications and infringement.
Time.
So returning to the mesh network, setting aside the novelty added by strain gauges and the inflation chambers, how would you react to a rejection that said it would have been obvious to combine the other aspects of the invention with mesh networks taken from other areas of art besides medical devices?
So while mesh networks did exist in the network art at the time, we'd like to note that the Chirikov application that was filed did not incorporate it into their system. And so the absence of mesh networks in this case indicates non-obviousness for the application. And additionally, these mesh networks require decentralized communication between sensor nodes, which is a significant challenge for setting up and calibrating the system as well.
If I could add on to that, I would say that the complexities of integrating mesh networks into systems further indicate that it's not a straightforward or obvious step to take, and that the inventive step in this particular case lies in how the inventor overcame the technical challenges and was able to incorporate it into the artificial womb environment.
And what in the specification would overcome that? So like if there are challenges in making it work in the artificial womb environment, is there disclosure about how you would do that vis-a-vis just slapping on a well-known mesh network onto the artificial womb context?
I believe paragraph 31 of our specification enables mesh networks, but due to page limitations, I'm not sure if we included as much disclosure about actual implementation of mesh networks.
If your client or the inventor were to come to you and say, okay, we have this patent application, it's in process, where do we go from here? What advice in terms of licensing, building out the portfolio, what other strategies would you have to him or her?
Regarding future considerations, we would file continuation applications in order to keep prosecution pending and the ability to amend new claims. We would also look at potentially filing international applications in countries with advanced neonatal care hubs where demand for the technology would be high. Additionally, we would consider filing applications claiming specific elements such as the microprocessor configured for use in the artificial womb system in countries such as Taiwan or China. And this would help us to ensure protection in regions with strong commercialization potential while also minimizing unnecessary prosecution costs.
Were those international recommendations based on prior art that you found, or just based on or solely on where other manufacturers or opportunities for sales would be?
Both.
If your client, suppose the claims you drafted were granted and issued or allowed and issued, who would you advise your client to monitor for infringement?
We have identified the Children's Hospital of Philadelphia as that's associated with the flake patents. And also the Extend artificial womb system is a current commercial application that may be in the future developed to have some of the elements that we have in our patent.
What about licensing strategies? What if the inventor said, I can't fully fund this, or what exit strategy would you provide to me based on what you've seen in the prior art or the other parties, competitors in the market?
I think with respect to licensing, in this case, we would also advise our client that those same potential infringers could also be good sources of or good avenues to have initial discussions with for the potential of licensing or some sort of joint agreement in providing funding for these applications, and then potential patents once granted, and then would have an agreement for their use.
Thank you.
Thank you, Arizona State University.
On behalf of the U.S. Patent and Trademark Office, I would like to thank all of our competitors today for extraordinary advocacy, presentation of your materials, and responsiveness to our judges. Our judges are now going to take this time for their final determinations, for our calculations of the scoring. So for about the next half hour until about 1:30, we are going to have the opportunity for networking amongst the teams, the mentors, faculty, advisors, and sponsors that are here, as well as some of the USPTO staff. At 1:30, we are going to have the pleasure of an address from several members of the USPTO's senior leadership staff, and then, of course, that will be followed by our awards ceremony. I hope when all of you were in the adjoining half of the Clara Barton Auditorium, you had the opportunity to pick up some of the materials we had available for your use and future reading. And in addition, on the chairs that are here today, we also provided you with some of our much beloved Inventor Trading Card series. These are a series of over 20 cards that have been produced over a series of 10 years to reflect the diversity of inventors, diversity of ethnicity, gender, technology, and are used as a teaching tool for inventors, innovators, and entrepreneurs of all ages. So we hope that you'll take your Inventor Trading Cards with you and enjoy them and share them with members of your family and community. But again, we have about 30 minutes to network with one another. But maybe we want to do that in the adjoining room so we can allow our judges time to confer.
We're going to be joined by Molly and Darius Banks, who are the co-chairs for the National Patent Application Drafting Competition. I understand they're online. And we have been also joined by Valencia Martin Wallace, our acting commissioner for patents. And I told her that this will be an informal chat, so you all can go gather around her after Darius and Molly speak. She's been joined by Stefano Carmes and Erica Miller, and I understand a few other people will be down to say hi to you. So let's hear a few words from Darius and Molly, and then we'll look to our other leaders for some further guidance. Thank you.
Thank you, Karen, and thank you, everyone, for participating in NPADC. It is just a privilege to listen to you all this morning, all the hard work, dedication, and time that's gone into your presentations, as well as your preparation. It was truly incredible. As someone this is my first year actually supporting this initiative, it was incredible to hear you all. And not only just this, but during the regional rounds as well. So again, my remarks are going to be short. I think the real people you want to talk to are the Commissioner for Patents and the Deputy Commissioner. But I just, again, want to say truly, it was just enlightening to hear you all this morning. So all due the credit to you, and thank you, judges, for your time and participation in this program. Karen. I don't think Molly's here. She had a problem getting on. So I think we're going to turn it to Karen or to Elizabeth.
Well, y'all have heard from me enough. So again, the real excitement has just entered the room, and this is our patents senior leadership team. So I'm going to turn the mic over to our acting commissioner for patents, Valencia Martin Wallace, who is also an attorney, and she's going to introduce the team that she's brought with her here today.
Just say hello to all of you. Thank you so much for the amazing work that you've done. I've been hearing from Karen Ferreter about the entire process and how stellar your work has been. So happy to be here with you today. And I will introduce myself and then ask each of the deputy commissioners to also introduce themselves. So my name is Valencia Martin Wallace. My permanent position here is as deputy commissioner, and I have oversight of our international cooperation area as well as a couple of technology centers, electrical and mechanical technology centers. And I started here as an examiner. I actually started working here first before I went to law school, and did them simultaneously and enjoyed my experience here so much I decided to stay and not move to a law firm or corporate. And I've been here for 33 years and have not regretted a single day of being here and the different experiences that I've received in working with technology and laws and how to integrate the two. So I'm going to stop there because I'd like to leave time for your questions, and I'll ask Charles Kim to introduce himself.
Great. Thank you, Valencia, and good afternoon, everyone. As Valencia mentioned, my name is Charles Kim, and I serve as one of the Deputy Commissioners for Patents here at the USPTO. I currently oversee the patent examination policy areas within the Patents Business Unit, and those areas include our Office of Patent Legal Administration, or OPLA. OPLA handles many of our notices, including our Federal Register notices. They developed our subject matter eligibility guidance, or our PEG. Many of you may be familiar with that, as well as a variety of other activities across the agency. The other area that I oversee is our Central Re-Exam Unit. So the Central Re-Exam Unit, or CRU, they handle primarily 3 types of post-grant proceedings, right? The PTAB handles certain types of post-grant proceedings, but the CRU handles ex parte re-exams, reissues, as well as supplemental examination. The other area that I oversee is the Office of Petitions, and that office handles over 45 different types of petitions and issues over 40,000 petition decisions a year. The fourth area is our Office of Patent Quality Assurance, and we call them OPQA. OPQA is staffed by senior examiners that review the office actions are issued by our examiners. So they do a random review of over 12,000 office actions per year to make sure that our quality standards are met and that we're taking steps based on that data, whether it's through training or taking other steps to make sure that we continually improve our quality. And the last area is the Manual of Patent Examining Procedure, or NPEP. You may be familiar with that as well. So that staff makes updates to the NPEP, which typically takes a couple of years based on updated guidance and other documents that we've issued. I do want to, before I turn it over to Jerry Larango, I do want to thank all of you for participating in this event. Learning how to effectively draft patent applications is really important, right? Because the quality of the applications that come in the door make a big impact on the quality of the patents that we issue that go out the door, right? So thank you for stepping up and participating in this great program.
Thanks, Charles. As Charles mentioned, I'm Jerry Larengo. I'm one of the other deputy commissioners. It's nice to see Linda here in front. We worked with Linda a lot on IPRs for a while. I oversee 2 technology centers, TC's 2100 and 2400. Heavy software, 2100 is where AI lives, 2400 is where MUX, multiplex communication, lives. The other areas that I oversee are the Office of Patent Financial Management. So it's been a very busy time of year over there for them. Also the Office of Patent Data Analytics. We basically do all the data analysis for the entire patents business unit and everybody else in the office who needs some data because, well, we're 10,000 of the 13,000 people here at the USPTO. The other portion that I have is the project manager's office. They are our experts in project management that help keep us all on task. And besides, the last one is Office of Patent Workforce Management. That's kind of our internal HR group, or HR expertise that help manage the 750 supervisors, 8,500 examiners, and all the group directors and SCS to kind of work together. Quick background-wise, I have been here a little over 28 years. I started as an examiner in 1700 as chemical materials engineering, became a supervisor in 2005, joined the SCS in 2012, and then served in the biotech group 1600, and then in 3700 before becoming an assistant commissioner in 2020. I also went to law school here full-time like V did. I graduated from Catholic in 2003. I thought I would leave after law school, but I stayed because it was the people and the mission. And the law school feels like yesterday. I realize it's a lot longer ago than that now. But welcome. Thank you for coming. Thank you for participating. Like Charles said, if it's not for the applicants, there's no point us being here. And we all serve them to make sure they get the innovation coverage they need. And it all comes through your skill in drafting. So thank you very much.
All right, thank you, Jerry, and welcome everyone to the USPTO. So my name is Stefano Carmis, and I'm serving as an acting deputy commissioner. So you heard Valencia mention that she is serving as an acting commissioner. I'm serving in her normal full-time role while she is serving in that position. So as she mentioned, that area oversees a lot of our international work, and in addition to a couple of technology centers, which I will get into here in a minute. I do want to say I myself started in 2002 as a patent examiner, and I have to say one of the things that always kind of stuck in my mind is examining can be a challenging job, but I was always kind of happy I wasn't the one that had to write the application, because that seems like a very challenging job. And so kudos to you for all taking on that effort. I've looked at, hundreds of thousands of patent applications, I'm sure. And always impressed by the work that gets done and how difficult that job can be. So one of the areas that I oversee is our PCT efforts, or Patent Cooperation Treaty, which maybe some of you know about. And as you can probably expect in today's day and age, just getting a patent in the United States is not always the answer for inventors. So what this treaty allows inventors to do is to try to seek patent protection in a more efficient way overseas as well, using a single drafted patent application that can then be taken into different countries. So really as Charles mentioned, the importance of having that quality drafted patent application is important for us. And it can be difficult when you have to think about going into multiple different offices that maybe have different legal considerations also as you do that. Also oversee right now the classification area. So maybe some of you, when you were writing up your patent application, spent a little bit of time doing classification searches or thinking about what kind of classification the applications you're drafting might fall into. And then I'll just say we have a handful of other related organizations that focus a lot on how we collaborate with other offices, how we share information with them, how we can partner with them on various work sharing agreements. So it's kind of the area I cover. Again, just want to welcome you all, and very excited to be here with you all today. Thank you.
So we would love to take any questions you might have about us, about our careers here, as well as the opportunities here at the Patent and Trademark Office, or just, IP in general. So please, just stand and ask. Or come up to a microphone and ask.
We're mostly harmless.
Hi, I was just kind of curious, what opportunities are here for students?
So I'll start, and we can all jump in as well. So we have intern as well as extern programs where we can bring students in. Usually it's in the summertime, to get experiences in different areas of the USPTO. So certainly in the patent examining area and the examining core, but also we bring people in on the PTAB, our Patent Trial and Appeal Board side, and the Trademark Trial and Appeal Board side, some other areas. So there's a wide range of experiences. Besides the extern and intern programs, and she's sitting in the audience. If she doesn't mind, yeah, stop looking in the back. We know you're one of our other deputy commissioners, Robin Evans, in the audience there, and she runs programs that help both IP professionals as well as the general public have a better understanding of the patent examination experience. And I'm just going to have to ask you to step up for a second, Robin, and maybe share about some of the programs we have like STEP and SOAR.
Well, thank you, Valencia. Madam Commissioner. Good afternoon. Good afternoon, everyone. Again, we are happy to be here. Thank you all for coming. We do provide a number of different programs, as our acting commissioner said, where we try to provide information for those who are working in the IP community, those who are practitioners. We have a program we called STEP, and that's the acronym, Stakeholder Training Experience for Patent Program. That's something like professionals. And that's really so that you can have an inside look of what's going to happen to your application as it comes through the door. So from the eyes of the examiner that will be examining the application, what they will go through, how they will examine the application, what your responsibilities are when you meet with them, how they will search your case, and we provide a little bit of searching training from that standpoint as well, just so you know what to expect, so that when you meet with an examiner, that you're better equipped and that exchange will be impactful and will help move the application along. We also we have a program, it's called SOAR, it's Stakeholder Offerings and Response Resources, and that's really an umbrella. So we have chats, webinars that we are going to restart soon, but it's really to give you what you need at the time you need it. So when you're before the office, whether that is as a applicant, a practitioner, that you really have what you need. So if you're searching on behalf of your applicant, or if you're an applicant yourself, you know how to navigate our systems, because we want folks to remain engaged in the system and in the ecosystem. So we have a lot of programs like that, and we're always open to suggestions. So if you have any ideas or information that you need that you don't see out there, please let us know.
All right. Thank you, Robin. And we have that program, so many more. And just to let you know, so I know we're running a few minutes late on our program, so we'll stop now. But all of us, Robin, Charles, Jerry, and Stefano, will be here in the audience. So if you have any questions or just like to chat with us a little bit more, please just step right up to us, and I will look for Karen or Nancy. Is Nancy here? Oh, there she is. Thank you all. Thank you all, and good luck.
Hello, everyone. I'm Nancy Kamei. I'm the Chief Public Engagement Officer here at the USPTO. And first of all, I just want to offer my congratulations to each and every one of you for being a national finalist. That's a wonderful accomplishment, so bravo. And now it's my pleasure to introduce the Acting Director of the U.S. Patent and Trademark Office and the country's Under Secretary of Commerce for Intellectual Property, Coke Morgan Stewart. Director Stewart is an IP expert and an IP champion. She worked at the USPTO for 10 years before returning in January to lead the agency. While she was working here from 2011 to 2021, Director Stewart was in the solicitor's office involved in dozens of Supreme Court cases and numerous administrative law cases in the U.S. district courts. She also had extensive experience working in the USPTO's Office of the Undersecretary. Among other roles, Director Stewart served as Chief of Staff, Senior Policy Advisor, and Acting Deputy Director of the agency. She's a very successful litigator and a great advocate for the IP system. And just so you know, since you're all in law school, she went to Duke University as an undergrad and then received her law degree from the University of Virginia Law School. She also clerked on the U.S. Court of Federal Claims. So Director Stewart, it's such an honor to have you here to provide some remarks and to announce the winners.
Great to see everybody. See her. Thank you, Nancy, for that kind introduction. I'm so excited to join you all today. I think, so are these our judges, Linda? This is where the judges sit? And then the presenting was up here? Okay. Okay, well, first, welcome to USPTO. I hope you love our beautiful headquarters here. Have any of you been here before? No? Okay. Well, thank you for traveling to come here for this. And of course, you're our group of finalists, so you had to come here. We hope you get to enjoy some time in the area outside of this, and I'm sure it's a big relief to have it all be over right now, and you can just kind of enjoy and think about the process. Also, congratulations, as I said, for making it to the finals of the application drafting process. And how many schools participated this year? Anybody know? Wow. Okay, so you're the top 5 of all the 43 teams. That's amazing. We're very proud of you. We're very excited about this program here at USPTO, and I know you had to work very hard to get to this point. Also want to thank our judges. Brad, thank you very much. Linda, I think Nick Matich is in the back there. Thank you so much for taking your time to judge all the teams today, and also to all the staff and judges from the regional offices. I know some of them may be online watching. I know they're very excited to see what happens today. People get very invested in this. I know you are, but we all are too, and we want to see what happens with all of the teams. In fact, I taught law school at Regent University School of Law in Virginia Beach for a period of time, and we were trying to develop a team to participate in this contest. I don't know if they had one this year, but everyone was very excited about it. I also want to thank all the mentors who were helping with the teams, and the members of the faculty from the university who were supporting you all. That's obviously very important. Your coaches and your families, of course, to have you participate in this process. Can I ask how many people have an intention to actually practice patent law after this? Most everybody? Not exactly everybody? Okay. Well, when I started practicing law, I was doing corporate litigation, and I ended up being an IP lawyer. So we may still be able to bring you back into the system if you're not sure. I just want to say to you all, don't take what you're doing for granted. We really view you all as the future IP lawyers, and probably some of you future IP leaders in our system, and that's very important to us. And we spend a lot of time talking about the history of the IP system and the fact that it dates back to 1790, because that was the first time Congress started passing laws in this area. And it's even in the Constitution. I don't know if all of you know that. It's in the Constitution in Article 1, Section 8, Clause 8. So we take great pride in our patent system and the fact that it's in the Constitution, and also to know that the knowledge and the skills that you all are developing through programs like this and through hopefully practicing IP law is really what drives the U.S. economy, and that's just so important. Until we issue these patent rights, new technology may never be commercialized. It may just, people don't necessarily want to invest. If any of you have watched Shark Tank, you probably have. One of the first questions they ask, which is, anyone?
Do you have a patent? Right. So patents are so important to our economy, and that journey really starts with having a high-quality patent application, which is what you all were doing today. So yeah, as I'm learning, the competition featured 43 teams from the U.S. as well as 1 team from Canada, which is fantastic. Our 5 finalists, I'm a big sports junkie. We're sports junkies in my house. So immediately when I saw the teams, I said, I want to know the mascots for all the teams. So we have the Gophers from Minnesota. Will you raise your hands so I know you are? Okay, great. We've got the Panthers from the University of Pittsburgh. Okay. We have the Badgers from the University of Wisconsin, the Tomcats from the University of St. Thomas, and the Wildcats from Arizona State University. Sun Devils. All right, Janet. And I know all of you, this is not required to win today, but I know all of you are supporting Duke in the NCAA championship. Right, you have to. Anyway, we're just so happy to have you here today. I'm so excited that you're part of the finalists. And frankly, I know how hard it is to be a law student and engage in this process of drafting patent applications. So congratulations again to each of you for how far you've come. And I think we're getting close to announcing the winners. This is the moment you've been waiting for, the results of today's competition. And I think we're going to start by announcing the 3rd place winner. Is that right? Okay. Okay. Do I have a microphone? Do I need a microphone? So first we're going to announce can you hear me okay? The 3rd place winner, which is, this is like the Oscars, University of Wisconsin Law School, Brent Brunner and Ronko Young. Right here, are they coming up? Yeah, please come up. Okay. Yes. Okay. Okay. Congratulations. Here, let me put this down so we can have a quick picture. All right, now we're moving to our 2nd place team. Drum roll. The University of St. Thomas School of Law. Sure. And finally, our winner of the 2025 National Patent Application Drafting Competition is University of Minnesota Law School. go back over. I'm just going to go back to the podium. It's a little easier for me here. So just to close, on behalf of the USPTO, I just want to thank everyone for their efforts in participating in this remarkable competition. We really appreciate everything you've done to get to this far. And just remember, there's a great future for you in practicing patent law. You will work with some of the most innovative people in the world. You will always be challenged. You will always be rewarded. Maybe some of them, Valencia, will come work at the USPTO. And I just want to thank you so much and return it back to Nancy to close things out. Or Elizabeth Doherty. Thank you so much. How about another round of applause for our acting Undersecretary and Director, Coke Stewart? This event wouldn't be the same without her recognition and praise for our award winners. Again, we recognize you all as winners today. You competed admirably in your regional rounds and here today in the finals. I hope that you'll take the opportunity to stay and engage with the judges, engage with the patent senior leadership that is here in the room with you. And I know this is the National Patent Application Drafting Competition. We do have a trademark colleague in the house too. For those of you who have an interest in trademarks, I'd like to call out Marisa Terrell, who is sitting in the far corner, who has graced us with her presence today too. So if anyone is interested in getting to know a little bit more about trademarks, you have that unique opportunity. But please stay and engage. We'd love for you to interact with our senior leadership that's here with you today, because today is all about you and your learning experience. So thank you. Thank you for being with us.